The trial in this matter is held in the DIFC course. The case number is TCD 009-2022 before Justice Lord Angus Glennie and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instruction. The claimant is represented by Al Aidaros advocates and legal consultants. Lead counsel is Martin Kushdal. The defendant is represented by Charles Russell Speech Leads, LLP. Lead counsel is Thanos Corvelis.
Yes, thank you very much. Right. Looking at the timetable, it says housekeeping first. What points of housekeeping are there?
My lord, the one housekeeping that we have at the moment is just quickly to discuss the timetable, because I think a query came about whether or not the timetable incorporated evidence in chief, supplemental questions, and cross-examination. Our position is that we want to ask Mr. Akiki and Mr. Lowe additional questions in chief. And our recollection is that your lordship said that that would be fine as long as we communicated that with the other side, which we have done. And we propose to limit it to about 15 minutes or thereabouts each. And that's in addition to the usual introduction of witnesses and evidence in chief in terms of the witness statement. And primarily we want to deal with some matters arising from the expert report from Mr. Spordy, and in respect of the experts themselves, there isn't a joint memorandum for the delay and quantum experts, and that's Mr. Lowe, Mr. Spordy, and Mr. Craig. Given that fact, we wish to ask Mr. Lowe some additional questions in that context. So that's our housekeeping for today.
Yes, Mr. Carvelis, that's all right by you, is it?
Not entirely, my lord. Yes, my learned friend did communicate to us their intention to ask supplemental questions to Mr. Akiki and Mr. Lowe, their two witnesses, factual and expert. However, I am not sure that we can agree to that. I think we have agreed, and this was recorded in the previous hearing we had, that the witness statements will serve as examination in chief. It is rather late in the process to introduce new evidence. I'm not obviously aware what are the questions that my learned friend intends to raise with Mr. Akiki and Mr. Lowe, but I think it would be rather unfair to introduce new evidence which we will not be in the position to address.
Yes, I see. We can leave aside Mr. Lowe for the moment because he's not coming till Wednesday. But yes. Mr. Akiki is due on today. Mr. Koshdel, have you given an indication of the precise questions you want to ask?
My Lord, I haven't, but I can indicate now. Mr. Sporley in his report refers to, unless I'm mistaken, five events, which he says informs his delay analysis. Closeout programs, handover documents, WhatsApp messages, variation order 4, and off the top of my head, I can't remember the 5th, but work inspection report request logs. And Mr. Sporley relies on these 5 to come to the conclusion that the claimant's delay analysis is flawed and shouldn't be relied upon, and in fact supports the defendant's argument on delay. I want to ask Mr. Akiki to give context to these documents, or to these 5 pieces of evidence.
Very well. Mr. Carvelis, it seems to me that it goes directly to points covered by evidence of other people, which of your witnesses, and in those circumstances, I allow some brief brief questions on those matters. And you can, if you decide to take it up with this witness, that's a matter for you, or if you decide to leave your powder in reserve until you come to your expert, then again, that's a matter for you. So I'll allow that to happen, provided it's kept within a very tight compass.
I understand, Your Honor. Thank you. I assume we will have the same courtesy will be extended to us then,
Yes.
in relation to all witnesses.
Mr. Koshdal, you
Thank
can't
you.
go to that.
Of course, I would have no objection. So
Can I just, the reason I asked the question through my clerk last week about evidence in chief and so on was you've allowed 30 minutes, 1 hour 45, 2 hour 45 minutes for Mr. Akiki. But does that take account of a certain amount of introductory and evidence in chief, or has that been left fluid? I mean, we don't want it. 2 hours 45 minutes could easily go by with you asking an hour and a half's worth of questions.
yes, for my part, can I say this about the entirety of the timetable first? There is a certain level of fluidity because we say that there is a realistic chance that this could all probably even finish on day 4. But putting that caveat to one side, as I say, I wasn't proposing to be long in chief at all with Mr. Akiki, just some brief questions. So the same would have gone for Mr. Lowe in any event.
Okay. Is this a timetable that I am meant to be insisting upon being adhered to? For example, if Mr. Akiki is not finished by 3 o'clock London time this afternoon, do I say, well, that's it, full stop, the next witness, or what happens?
Can I say this, that we understand from Mr. Akiki, he informed us recently that he will be traveling tomorrow. Yes, tomorrow, and wouldn't be available tomorrow. So we would ideally like Mr. Akiki to finish today.
That's a different part of the problem. I don't want to find that at 3 o'clock we have halfway through cross-examination of Mr. Akiki, and everyone then says, "Oh, let's carry on," because there's a limit to what the court can take in time-wise. Nor do I want to find that everyone stops and one side complains that, "Oh, well, I thought we were going to carry on till we've exhausted the questions." And if we're limiting the time, we're limiting the time. And I think we ought to be clear as to the rules before we start. Sorry, Mr. Carvelis.
Yes, thank you, Your Honor. Our intent, first of all, when we agreed with my learned friend the timetable, I have to admit we didn't give so thorough considerations as to, and we did not at that time factor in any examination in chief, except perhaps 2 minutes for warm-up. We did agree with my learned friend that we will be a little bit flexible. You know how it is, especially with cross-examination of witnesses. You can never know how much time you will need, and Mr. Akiki is the sole factual witness for the claimant. He made 3 witness statements, quite extensive ones, especially the second and the third. Our intention and we have organized the cross-examination so that it finishes by 3 o'clock UK time within the schedule, but we will know as we go. It will depend on whether Mr. Akiki will be cooperative as a witness. I am sure you understand what I mean. There are times that takes a little bit of extra effort and time to get what we need from a witness. So as far as the defendant is concerned, I confirm that our intention is to finish, to stick to the schedule, but we cannot guarantee that. I hear that Mr. Akiki intends to travel tomorrow. I'm surprised, if I'm honest, considering the importance of this case and considering that he's the only factual witness. We might actually, we had in mind, as the cross-examination develops, to ask you, Your Honor, whether at some point, after we hear all factual witnesses, it might make sense to have them together and let them discuss between themselves issues that they seem to be very far away. They have totally different recollection of the same incidents. If Mr. Akiki is not available, we won't be able to do it. Anyway, to cut a long story short, we will try, but I cannot promise that we will finish by 3 o'clock.
Okay. Well, as far as the court is concerned, there's a limit to how long I can sensibly sit, because after a certain time you hear the words, but you don't really take it in anymore. So I intend to stick to the hours on the timetable. If Mr. Akiki is not finished by 3, he'll have to continue the next day. Mr. Costello, do you understand that? And so travel arrangements may have to be rearranged.
I do. I've just been informed that Mr. Akiki is available also on Wednesday, Thursday, and Friday. So I don't know if that can be.
I think let's cross that. Let's not take up time.
Yes, certainly.
If you and Mr. Carvelis
Yes.
can liaise about that and come back if there's a problem. The other point I raised through my clerk was the lunch break of 1 hour and a quarter seems a bit excessive, is it? If we make it 1 hour each time.
Yes, certainly.
And that means that all the afternoon times indicated come forward by 1/4 hour.
Yes.
Yep. The only other
If I may, Your Honor, apologies to interrupt. There are 2 additional housekeeping issues. I'm not sure if you had anything else noted for us housekeeping, or my learned friend has any other, but I do have 2 additional points, if I may.
Yes, of course.
One is that Mrs. Claire Levine, our our forensics expert, which is scheduled to start her cross at the last hour of Thursday and then continue to carry on Friday. Yeah. She's on a plane on Thursday. She reassured me that she will be in time to give cross-examination. She's traveling to the UK. She reassured me that she will be in time, ready to commence her cross-examination, but with all the recent situation and the delays in the airports and everything, I think to be on the safe side, she was supposed to continue on Friday anyway. It does not change, it does not upset the schedule. I think it would be safe to consider that she can start on Friday, if my learned friend has no objection, and of course you.
Mr. Costello?
I'd suggest that we probably wait and see how things pan out, because one never knows how the trial.
I think that's. We may find we're into Friday anyway.
Exactly. Yeah.
But I note the request, and I think Mr. Costello is sympathetic to it, if it comes to that. Yes, Mr. Carvelis.
Excuse me, Your Honor.
You had another point.
Yes, and one last item. We communicated, we notified our learned friend, I believe earlier this morning, we came across the defendant, our client, came across one additional document which is directly relevant to the cross-examination of Mr. Akiki, to a point made by Mr. Akiki in one of his witness statements. We notified this document to the claimant, and we would like your permission to add it to the bundle. We intend to use it during Mr. Akiki's cross-examination. It's a short document. It's a 3 pages only table. It shouldn't be very difficult to navigate. Together with the email, it is a document that Mr. Akiki already has since 2019. It was attachment to an email sent to Mr. Akiki, so it should not be anything new to him or the claimant for that matter. And we would like your permission to add it to the bundle.
Mrs. Costello?
My Lord, what I will say is this. I've spoken to Mr. Akiki, and if your lordship allows it, then so be it. The issue is that it's not so much the fact that Mr. Akiki knew of this email, that in my submission shouldn't fly, but it's more that what else may arise as a result of this email. As we may need to look into further emails, and the admission of this email into evidence may result in other evidence having to now be brought up. Now, if your lordship permit, of course, it goes without saying that the application or the locating of this evidence is late, and that should go without saying, which my learned friend rightly acknowledges. So I'm not going to spend time making submissions on that. What I will say is, if my lord does accede to this application, then it may well give rise to other evidence coming up in case there is other relevant evidence that needs to be presented before you. So with that, those are the only submissions I make, but we invite you to take note of what the possible consequences could be. I don't know, because I've only had an hour to look at it, and so has my client for that matter. So they will need to look into this and see if there's any other material.
I note those points, but I think we'll just have to proceed as best we can. It seems to me desirable, if there is relevant evidence, that it be to the witness, and therefore allow the document to be added to the bundle. Can it be put into the CMS on the e-bundle? And if that gives rise to the need to produce further evidence or produce further documents, so be it. We'll consider that when we come to it.
Certainly. Just going back to the point about evidence in chief, would your lordship permit me to ask Mr. Akiki some questions on this document, given that it's been...
Yes, I don't see why not, Mr. Covey.
Yes, no, absolutely, Your Honor.
Okay, is that all the points of housekeeping you had, Mr. Carvelis?
I think so, yes, Your Honor.
The only thing that occurred to me was this. The pleadings in this case are somewhat diffuse because of the way the action has developed. And I'm not sure that I necessarily got all the points that arise in this case crystal clear. So what I would be grateful for, if parties together could put a short document. I don't want an argumentative document. I just want to know so I don't forget about claims that arise and I've overlooked them. Which claims, sorry, I want to identify the claims the claimant makes, the claims the defendant makes, and where they are found in the pleadings. Simple as that, really.
Certainly. My lord, I wonder if that could take place after the conclusion of the evidence. So whenever closing submissions are
it would help me. Okay, if it has to be that late, but if it could be done by tomorrow, that would be even more helpful.
Okay, well, we'll do our best. I'm sure we can.
Yeah, I'm sure you can do something.
Yep.
Thank you very much. Right, if that concludes housekeeping.
Your Honor, apologies again for the interruption. It just occurred to me that there may be one additional housekeeping issue raised by, actually, it is a claimant's housekeeping issue, which I just realized that they didn't mention. We have the closing submissions, which is due at the end of July, I think, and in their skeleton, they asked the question whether we should also have reply witness statement, closing submissions. I don't know if it is something that you would like us to discuss now or at the end of the trial.
I should say, my lord, that's right. Although the final sentence I wrote is whether this should be considered at the conclusion of the trial, because I think we might be in a better position then and not delay matters into the evidence, but open to discussing whenever.
I think it's better to consider it at the end of the trial when we know. Well, you'll have a better idea as to whether they're going to be necessary.
Yes, exactly.
Very well, thank you. Right, so the next matter is your opening submissions, Mr. Costello.
Yes. Well, my lord, I'm grateful. I should indicate I'll try and be less than an hour to try and save up some time, and there are extensive submissions provided by us and indeed by my learned friend already, which I hope my lord has had a chance to look at.
Yes.
So
you mustn't assume, Mr. Costello, you mustn't assume I've taken in every detail, because there's quite a lot of stuff.
Indeed, I'll try and bring up salient points and to try and cover the main areas.
Yes.
I could say before I continue, there is also an agreed chronology, and also an agreed. We've called it jointly agreed facts, and I don't know if my lord has read those yet, but they're in the A section. In terms of the agreed it's called agreed background. At A6 of the bundle, you'll see paragraph 7. I haven't raised it to my own friend, but it's a typo as opposed to anything else. I don't think it's going to be controversial. But in paragraph 7, it says on the 1st of June 2017, 5 and the main contractor entered into a contract addendum. That should be July. I don't think there's any dispute about that. And I can see my own friend is nodding. But if there is any dispute, I'm sure he'll let you know. But we'll be looking at these documents at some point anyway. So just for your lordship to know that should be July 2017. And in fact, it says the same in the joint agreed chronology, point 7.
Point 8.
Point 8. Yes.
It says 1st July, yes.
Yeah, 1st of July.
Yep.
So with that, that was the only matter I just wanted to correct before I go straight in. Well, my lord, the parties in this case are 5 Real Estate Development LLC, and I'll refer to them as 5. Reem Emirates Aluminium LLC is the defendant. I'll refer to them as Reem. Within all of this, in the background, is another party called Limited One Limited. I'll call them the owner. The owner engaged 5 Real Estate Development LLC via a property development contract dated the 1st of April 2014, with a delivery date of the 30th September 2018 by an amendment made later.
Mr. Costello, could you stop for a second? There's some noise
sorry,
going on.
I can't hear you.
I'm not muted.
No, I can. Yeah.
Some noise going on in the background. Clicking. Stop now.
I can hear it I can hear a slight echo.
I get a sort of feedback when I.
Yeah. I wonder if it's if someone's microphone is not muted.
I suppose it could be my mobile.
Would you like me to just carry on to see how we go?
Yep, sure. Thank you.
Although I can't hear any feedback now, so I hope that's done it. But so as I was saying, the owner engaged the claimant 5 with a delivery date of 30th September 2018. Mr. Ikiki is 5's chief executive officer. He is the only factual witness who will be giving evidence in this trial. The parties negotiated on the subcontracted works, which led to a letter of intent. That's dated the 4th of July 2015, and it was for the supply and installation of aluminium and glazing works. And in fact, there was eventually a work order issued by 5 to Reem, and the date of that is the 19th of April 2016. That's at point 4 of the chronology.
Yep.
There is a slight dispute whether, and although I say dispute within in inverted commas, whether or not the Reem began works immediately or close to immediately upon the issuance of the letter of intent in 2015, or whether or not it was in 2016. The reason why I say inverted commas, because it may be resolved through evidence. The claimants, from the claimant's side, in terms of 5, the position is that physical works began in 2016, but non-physical works, designs and so on, took place in 2015. But in reality, it probably won't affect your determinations too much when we come to it, for hopefully obvious reasons. But I put that position forward to the court just so you're aware of the potential area. There is an undisputed incident which occurred on the 6th of August 2016, and that was what we call the fire incident. The building sustained a fire, following which 5 and main contractor, they are China State Construction Engineering Corporation Middle East. I'm going to call them China State for ease of reference. 5, China State and all other subcontractors, we say, engaged in negotiations to restart the development of the hotel. A number of meetings took place, and there is some evidence of those meetings in the bundle. In some of those meetings, which we'll see in due course, perhaps during the evidence, notably in May, and I think it was in June as well, there was references to Reem having to catch up with their delays, and that's in 2017. But as I say, we'll come on to that in due course. For similar, as I've said, similarly, it may not become a big issue for you to determine for the reason that I'm about to explain. Following the fire incident, works resumed. That eventually led to the addendum to the contract, which we just looked at now, dated July 2017. In that addendum, the time for completion of the project extended from November 2017 to the 25th of October 2018.
Mm-hmm.
As I say, that came in July. That was addendum number 1, and within addendum number 1, there was a novation of the subcontractors' agreements with China State to 5. However, Reem was the only subcontractor not to have had a contract with the main contractor, China State.
Mm-hmm.
Now, after July 2017, I think it was in or around November, the exact date will be provided in due course, I'm sure. An extension of time, it's called an interim extension of time, that was submitted by Reem, seeking an extension to March of 2019.
Yeah.
Thereafter, the parties being 5 and Reem engaged in negotiations. That started as early as September 2017. They engaged in negotiations to sign the subcontract agreement. The subcontract agreement incorporated addendum number 1. And as I say, addendum number 1 had a completion date of 25th of October 2018. Our case is that the signing of the subcontract agreement, which appears to have been on the 4th of June 2018 by Five and Reem, set a completion date of the 25th of October 2018, and de facto compromised the extension of time submission. So putting it a bit more clearly, the extension of time sought an extension until March 2019. Addendum number 1 set a completion date of October 2018. That agreement is incorporated, addendum number 1 is incorporated into subcontract agreement, which postdates the extension of time claim and therefore set a completion date of October 2018.
All right.
Then we come on to the subcontract agreement itself, just to look at it in a bit more detail. And the main clauses that you will look at are 4.5 and 4.10. 4.5 deals with extension of time, prolongation, and the like. And in particular, paragraphs 12 onwards of my skeleton, I deal with that in more detail. 4.10 deals with the indemnity, but I'll deal with that separately. 4.5, we say needs to be looked at in more detail, and 5's position is, and we can look at it, in fact, as part of the opening, it's at NA9, which is page E457.
E457.
E457 is the beginning of the subcontract, which we'll quickly look at just so I can make a couple of points here.
Yeah. Yeah.
It says dated 29th of May 2018, which there's no real issue on that, save that it appears that it was signed on the 4th of June, but it's probably not going to make much difference at all. Under clause 1.1, you will see that my reference to contract addendum number 1 dated 1st of July 2017 being incorporated. That's the 7th item in that list.
Sorry, you've lost me.
Sorry, if you've got the subcontract agreement open, clause 1.1 has a documents list.
Yeah.
And if you see the 7th item on that list, it says contract addendum.
Yeah, okay.
Yeah. And there's another point which shouldn't be of dispute. Item number 2 is the incorporation of FIDIC, which is purportedly annexed to this agreement, but the parties agree the wrong version has been annexed and the correct version has been provided separately. But I won't trouble you too much on that right now because that will come out more clearly in evidence in due course. So moving on to clause 4.5, which starts on page E460. The first sentence states quite expressly, the subcontractor shall follow the revised program of works attached with the subcontract agreement as per addendum number 1. That's the addendum 1 of the 1st of July 2017. The employer shall manage and supervise the subcontractor to ensure timely completion. The subcontractor shall submit daily, weekly, monthly reports, etc. And then there is a sentence beginning, as at the date of this subcontract agreement, the subcontractor has to be paid all payments due under the subcontract for the works done until the end of March 2017 from China State, i.e. until payment certificate number 19. And then the next sentence onwards is perhaps where we're going to be, where this litigation is going to focus on. Additionally, the main contractor, being China State, has accepted liability towards the claims raised by Reem on the fire incident of 6th of August, as referred to in a letter dated 27th of May 2018. That letter is an exhibit in this case, and you'll be referred to it in more detail in due course. That shall form part of this subcontract agreement. However, not limiting the claim to the car policy, that's the insurance, The main contractor, China State, shall additionally pay all reasonable costs of prolongation claim made by Reem, substantiated and approved by the engineer and the employer, being 5, which shall be settled within a reasonable period before closing Reem's account. In the event of China State being in breach of this obligation, then 5 shall deduct such reasonable and approved amount from China State and pay to Reem. Now, I've read it out because we say the following can be derived from the agreement. And this is paragraph 13 of my skeleton argument for your reference. First of all, Reem is required to make a claim for prolongation costs and/or an extension of time. We say the extension of time, which I've already referred to, EOT1, has been compromised with addendum number 1, incorporated specifically by the subcontract agreement. So there needs to be another EOT claim and a claim for prolongation costs. Secondly, China State shall indemnify, it should say, China State's insurer will indemnify China State. C, China State will manage the claim process with the insurer. I'll take you to the letter in a moment that deals with that. Fourth, any prolongation claim must be substantiated. It needs to be evidenced, we say, not just a spreadsheet or a schedule. That's not enough. It needs to be evidenced properly. Any prolongation claim must be approved by the engineer. And the same goes again by 5. Any prolongation claim must be approved by the claimant employer, being 5. The reasonable cost of the prolongation claim would have to be settled within a reasonable period of time before closing Reem's account. That assumes that we get to the point where the claim has been substantiated and approved by the engineer and 5. If and only if China State is in breach of we say its payment obligation at this stage, when we get to this point, then 5 must deduct that amount which is considered reasonable and approved by the engineer and the employer from China State from its account and pay Reem. All in all, we say there are a number of steps that must be satisfied before we get to the amount that is payable to Reem. We say that these steps have not been fulfilled. On the one hand, the addendum number 1 is a recognition of, it's a revision of the time for completion. And so a claim for prolongation can be made. You will see in due course that there were letters submitted by Reem saying that they are claiming for their prolongation costs, as outlined in the skeleton argument. But we say that Reem has failed to substantiate, evidence their claim for prolongation costs. And therefore, neither the claimant nor China State are in breach of their obligations under clause 4.5. We even say that prior to the signing of the subcontract agreement, when Reem submitted its claim on the 8th of February 2018, there was a letter from the engineer dated the 27th of March. That's at E825. E826, actually. That's the letter of the 8th of February from Reem to the engineer, claiming 9.9 approximately million in prolongation costs, 1.079 approximately in damaged materials, and following which comes the defendant's Reem's schedule, a spreadsheet outlining their costs in a table for the 9.9 million and the materials damaged by the fire. But 5's position is that this is not a substantiation. This is just tabulating it. And there needs to be proper evidence submitted to the engineer and 5. Following which, at the end of this exhibit on page E3834. This is the letter dated 27th of March 2018, making reference to the 8th of February letter. It notes that 5 has clarified to Reem about the responsibility of the prolongation cost and fire incident claim as explained in Addendum 1, but furthermore, this is the key point, following the meetings between Reem, China State agreed to sign a separate agreement to undertake responsibility of the fire claims. And at the end, it says that the engineer makes it clear that this should not be taken or deemed to be used in acceptance for an entitlement for an EOT or prolongation costs, as this shall only be made upon concluding the above with full substantiated events and supporting documents. Now, I appreciate this is before the subcontract agreement, but this is during the period of time when the subcontract agreement was being negotiated. This understanding has also been, I say, reflected within the subcontract agreement. The materials that have been damaged is the next point to consider. As I say, the claim was for 1.079 million. That claim was made on the 20th of October 2016. No issues with that. The issue here comes to whether or not the parties agreed to settle this at 750,000 dirhams or 850,000 dirhams. The relevant correspondence and indeed the evidence that you'll hear on the various meetings is in August of 2019.
So where am I on your
oh, sorry.
skeleton?
Paragraph 16 onwards.
Oh, yes, okay, yep.
Yeah. I've made references to the exhibits in there. I'm not going to necessarily take you through them now because, again, this is going to be looked at in evidence in more detail. But we submit that these letters, including the acceptance from Reem for 850,000 dirhams, was on the understanding that the claim for prolongation costs, which at the time was estimated to be 9.9 million, roughly, was compromised. It was agreed between the parties, between specifically Mr. Al-Mahdi and Mr. Kiki, that Reem will not be pursuing the 9.9 million costs because they couldn't substantiate it. And therefore, the eventual agreement at that stage was the 850,000 dirham agreement. Later on, this isn't at this point in my, oh, actually it is, paragraph 20 of my engineer's determination, of my skeleton argument, deals with the engineer's determination. The engineer had determined that 750,000 was payable for materials damaged, not 850,000 dirhams. The witnesses will, I'm sure Mr. Kiki will in particular will be cross-examined on this point. But the suggestion is that the 750,000 was the appropriate amount, but it will be a matter for Your Honour, for my lord, in due course to consider whether it was 750,000 or 850,000 dirhams. Significantly, we say that the engineer did not grant the prolongation costs for the same reasons that 5 is saying in this case, they were not substantiated. And there was no evidence of the losses. Now, moving on briefly to the contra charges and the variations, paragraph 21 of my skeleton. In relation to the variations, 5 relies on clause 2.2 of the subcontract agreement, which gives the right to descope. And of course, to add to the scope of works. This is a lump sum contract agreement for 47 million dirhams. There's no dispute on that. The right to omit or to add is contained within clause 2.2 of the agreement, the subcontract agreement.
Yeah.
And of course, it is inevitably going to be a matter for my lord to determine the meaning of this clause. But 5 relies on that to demonstrate its entitlement to vary the works, and Mr. Lowe gives expert opinion on this in his report. Liquidated damages is directly related to the delay part, to the evidence that deals with delay. You would have noted that the claimant's case is, and as per the Mr. Akiki's delay analysis, which I'm sure you've had sight of, but that should be at Exhibit NA 31, unless I'm mistaken. Yeah, NA 31, from pages E1093 to E1105. I don't, at this stage, need you to go there yet, and it may be something we look at, as I say, in a moment. But just to set out some background on this, his delay analysis covers the period from the 15th of March 2019 to the 2nd of September 2019. In paragraph 28 of my skeleton argument, that's referred to as the third period of delay.
Sorry, where in your skeleton argument? It's okay, yeah. I got it, yeah.
Yeah, that deals with the third period of delay, because as Mr. Akiki outlines, and Mr. Spawley says this himself as well in his report, the progress of works follow up the levels, and level 59 is the final floor. You will also hear at some point that there isn't an as planned, as built program, and in fact, Mr. Spawley criticizes the defendant in that respect in his report. He also, I'm sure my learned friend will point out, that he also criticizes the claimant's delay analysis, but we will come to deal with that in due course. Mr. Akiki says, looking at the work inspection request from the Eaves subcontractor, EIFS, that's for level 59, that's the top floor, and that was on the 2nd of March of 2019. 3rd of March 2019, 3rd of March, sorry. Reem would have had 12 days to complete their works following the Eaves contractor, and I should say Eaves stands for Exterior Installation and Finish System.
Yeah.
They had 12 days. They didn't complete the entirety of their works until, in fact, well beyond the 2nd of September 2019, into the latter part of September 2019, we say even into October. But Mr. Akiki has limited his delay analysis to the 2nd of September because that's the day the hotel opened and began operating. And so he says that he reasonably limited it because that's the day that losses were being mitigated. Now, in paragraph 17 of Mr. Al-Mahdi's witness statement,
Yeah.
I'll just get I don't know if my lord needs a page reference, but it's on page EF for Foxtrot 3.
His first witness statement.
Mr. Al-Mahdi's witness statement.
So which one, his first or second?
Oh, sorry, his first witness statement.
Paragraph 19.
Paragraph 17, page F3.
Yeah.
Mr. Akiki outlines, sorry, I get the names mixed up. Mr. Al-Mahdi outlines the process to install the roof garden balustrade and the balcony balustrade. And he says, firstly, China State constructs the civil works. Reem will then send their surveyor to survey the works. Reem would install the U-channel. China State would then grout the U-channel. Then it's the waterproofing contractor. And then we say significantly, Reem will then return to install the glass balustrade, followed by the exterior installation and finish system contractor and the tiling contractor, but the tiling contractor is less important because the eaves contractor finished a day after, I believe, the tiling contractor. And then Reem will return back to apply the profile cover and the sealant between the eaves and the cover.
Mm-hmm.
Now, in terms of the delay analysis, we can look at it now. This is at NA 31, page E1094.
Hold on.
Yep.
Yep.
The top section, in terms of the analysis, demonstrates what should have happened, and the bottom half demonstrates what really happened.
So, take me through that a bit slower.
Yes, the top half shows what should have happened. So the green dot is China State completing the concrete completion. That was the 28th of March 2018.
Yeah.
Then the yellow dot, and we've got two. We've got one at number 2 and one at number 3. The one at number 2 is relevant because that's the later finish. That's the roof gardens eaves completion. That was scheduled for the 23rd of June 2018.
Yeah.
So we can ignore therefore number 3 because that's an earlier date. Then we've got the roof tiling completion, but that doesn't matter so much because it's only after the eaves completion really that the curtain walls would be installed and the balustrade glass, and that should have been by the 5th of July. So the roofs gardens tiling completion was a day sooner. But what really happened is in the second half. The concrete completion by China State, this is all level 59, I should say. The concrete completion was the 9th of September for China State. Eaves completed their works on the 3rd of March, 2019. There were some other works that were finished before the 3rd of March of 2019, so we don't need to be concerned with those. Reem would have had 12 days to complete the curtain wall glass and the balustrade glass to install them. That didn't complete until we say, in fact, when we look into the work inspection request logs, at some point, perhaps even in April or May. But in total, Reem had to apply the sealant and the cover. It had snagging works to complete, and then none of that was completed until beyond September. There was also an issue of broken glass, which we say Reem was instructed to replace and install. Again, that took place until August, September, October. So the calculation of the delays is from the date that Reem should have completed their works, which is 15th of March, up until the 2nd of September, because that's the opening of the hotel. Now, as I've said in paragraph 28, there are in fact 3 periods of delay. The first is between the 25th of October 2018 to the, sorry, that's not right. There was a period of delay which covered the fire incident, which was extended by Addendum 1. I haven't referred to that in paragraph 28 because Addendum number 1 deals with that. The second period of delay is between the 25th of October 2018 to the 15th of March 2019. Mr. Spawley has said that's excusable. We don't have a joint memorandum to know Mr. Lowe's view, but we on behalf of 5 submit that yes, it's excusable, but in fact, the problem is we don't have an as-planned, as-built to properly assess all of the delays, other subcontractors and Reem's own delays, whether or not Reem had its own delays or not that affected other subcontractors. So that second period is not going to be of much assistance. And Mr. Spaulding, in fairness, also deals with the third period of delay. That's really where we say this litigation is going to be focused on. And in that respect, we also will need to, in due course, as you would have heard me in the housekeeping part of the trial, there are some 5 issues which Mr. Spaulding deals with. The WhatsApp messages, handover program, closeout program, work inspection logs, and the variation order number 4. Variation order number 4 deals with the broken glass. That was issued on the 30th of July, 2019. The engineer's instruction that gave rise to the variation order came in on the 27th of June, 2019. So our point is, on behalf of 5, there is a period of delay in order to get the variation order, which we suggest should never have been dealt with in the way it was. There was an engineer's instruction to replace the glass. That wasn't done. Reem took time in order to get their variation order when actually it should have got on with the instruction and then sorted out the commercials at the same time or later. But so we say, therefore, this all contributes to delay being the cause of, Reem being the cause of the delay to their completion of their works. That's in a very, that's more of a summary. I deal with this in more detail in paragraphs 30 onwards of my skeleton.
Mm-hmm.
So paragraphs 31, I've already said, is not really an issue. Paragraph 32, we say, whilst it's said to be excusable, there were delay notices during that period, and the absence of an as-planned, as-built program means that not just that any delay notices against Reem, but also Reem's own delay notices are not really going to be of much assistance, because it's not going to be, it's not possible to assess it properly on the critical path delay, and that's where we say is the significance of that period. Delay number 3, as I've already outlined, is the main part, and that is dealt with in paragraphs 32 onwards of my skeleton argument. Paragraph 35 is where I make the point about the lack of an as-planned, as-built analysis. But what we say is that there are certain conclusions that can be drawn. Yeah, sorry, I was just pausing for Model just for a moment. At paragraph 36, we say there are certain conclusions that can be drawn. One, there was only one extension of time, one claim, and that was on the 26th of October 2017. There were no other extension of time claims submitted until December 2020, which is way after the engineer's determination. The subcontract agreement was signed on the 4th of June, which accepted the new Addendum 1 revision date of the 25th of October 2018. Reem's extension of time claims have not demonstrated an as-built critical path delay analysis, in the absence of which the court needs to consider other evidence. And the other evidence is mainly outlined at paragraph 39 of my skeleton argument. I know the friend is going to be saying that 5 delayed the handover to Reem. We say the difficulty is, with my learned friend's argument, is that when we look at in time at the work inspection request logs, the glass balustrade, which was supposed to be installed, was being installed but kept being noted as resubmit. That means not approved. So there was something wrong with Reem's installation of the glass balustrade. That continued up until April of 2019. But we know that handover to levels 41 to 59 was as early as the 23rd of April 2019, and other wings on the 59th floor were handed over as late as 9th of June. And we submit that indicates because Reem's works were not properly done and were not properly concluded for the handover to take place. Dealing with the WhatsApp messages, we say that that floors 39 and 40 were the floors where the cradles were anchored. Reem would need to complete their works to the other floors in order for these cradles to be removed and for works to be complete. Five's case is pretty simple. Reem was in delay. It couldn't be given access to the other floors because of their own delays, as in the mechanical floors of 39 and 40, and therefore Reem's any late clearance is Reem's fault. The work inspection request log I deal with next. That, as I've said, demonstrates that the glass balustrade installation was not being done properly. It had to be resubmitted. And the last submittal date for level 22, in fact, as noted by Mr. Spawley, was on the 30th of April 2019 with an inspection date on the 1st of May 2019. If my lord just bears with me one moment. Yep, that was on the 22nd floor, the C wing, and that was met with the code E. That means resubmit. As I've said, that means not approved. So what we can glean is at some time, just for level 22 alone, when we look at that in isolation. But the same goes for level 59 of significance, because that was also met with a resubmittal. At some point at the end of April until June, those works were completed by Reem in order for them to be given access. So again, similarly, the same point, it's Reem's fault why access was being granted later. The closeout programs next. We say that 5 says that this deals with the snags, and when we look at the closeout programs themselves, I've given the page references G2953 to G2955, and there's an email at G2956. This all deals with the snagging works. And then what follows from the snagging works are the desnagging works. Again, this all follows after the external balustrade cover and sealant works are completed by Reem. This is all delayed because of Reem's own delays. So we submit the closeout programs are again, similarly, not going to be of assistance. The variation order number 4. There was an engineer's instruction. We say it's clear and unambiguous. Reem says it's not clear. It's not, and in fact, they may even say it's not a proper instruction. We'll wait to see what they have to say. That was dated the 27th of June, 2019. You can find that at E1721 to E1722. The instruction stated that Reem was to replace all damaged or broken glass panels, balustrade glass, aluminium units, etc. In accordance with FIDIC, clause 3.3, Reem had to carry those works out. At the bottom of the instruction, I'm just turning it up if my lord just bears with me. Page E1722, you'll see it says NB just above the signatures of the engineer's instruction. It says all commercial issues will be evaluated or agreed later as per contract terms and conditions, specification requirements, if any. And then it says the EI shall not be taken nor be deemed to be used as an acceptance of entitlement for an extension of time. So 1, it's an engineer's instruction. Reem, you must get on with it. 2, any variations that you want can be dealt with later as is normal. And 3, this doesn't give you an extension of time as of right. Significantly, we also say, and I think my learned friend may make this point, that this alone would have also given rise to an extension of time. We say it's not as simple as that. It may do. We say may with emphasis, but it's for Reem to and for the engineer to evaluate properly in order to determine whether an extension of time should be granted in the circumstances. We say no. The engineer's instruction was clear, unambiguous. It should have been carried out, and Reem delayed the works in order to get a variation order. And even if we get beyond all of that, and if my lord decides that there is an entitlement to a claim for an extension of time, we go back to the point I made earlier. The losses were not substantiated to the engineer. Taking over certificate next, paragraphs 41 of my skeleton onwards. The defendant, Reem, will say that they sought a taking over certificate, TOC, to be dated 2nd September 2019. Under FIDIC, there was 30 days for there to be a response to such request. That request came on the 2nd of October 2019. 28 days later was the 30th of October 2019, and that's when we had the non-conformance notice 658. That's dated the 30th of October, as I've said. That indicated that there were defects to the door handles, and that Reem was required to attend to the snagging defects. Mr. Al-Mahdi accepts that they did not attend the defects. That's in paragraph 108 of his first witness statement. He says the works were complete and the defendant had left site by then. We say Reem was required to attend to the defects. And they didn't, and they're in breach of their obligations. All of this, of course, leads up to the eventual engineer's determination. Dealing with, I'm going to skip through quantum because it's been outlined to some detail in my skeleton, but I submit that it might be better use of court time if that's left until closing submissions later, because I think liability is probably more pressing at this stage. I'll quickly deal with the claimant's claims very quickly. There is an indemnity claim. It's made pursuant to clause 4.10 of the subcontract agreement, where it says Reem shall indemnify 5. If you need a page reference.
Which part of your skeleton am I on?
I'll take you to paragraph 51 of my skeleton. I quoted from 4.10, so that should save you having to look at the subcontract agreement.
Yeah.
Reem shall indemnify 5 from and against all loss, costs, damages, claims arising out of and or in connection with the performance, acts or defaults of subcontractor. There's going to be some legal argument here in terms of UAE law, perhaps again in more detail in closing submissions, but for now, as I understand it, my learned friend is going to be saying that the indemnity clause is not enforceable for the reasons he's already outlined in his skeleton. But we say that 4.10 was part of the agreement. It was accepted by Reem. It is a wide indemnity, but we're dealing with two companies that are very much experienced in the construction of buildings, particularly also with hotels. The two parties know each other from a different project, the 5 Palm Jumeirah project. So Reem can't say it doesn't have any experience in being engaged in as a subcontractor for work to do with a hotel, and it's very reasonable for an owner to seek its losses from 5 as the party that engaged with the owner under the property development contract. Those losses are being put onto 5. 5 is saying, well, it's Reem's fault. And under 4.10, Reem has to indemnify 5 from the owner's losses and its claim against it. I've set out at paragraph 49 and 50 a couple of paragraphs just dealing with the background giving rise to 4.10. I'm not going to take you through it because it's self-explanatory. Our simple position in terms of the starting point is Article 267 of the UAE law, which basically essentially says unless there is a breach of law, the contracting parties are bound by the contract. But I know my learning friend has made submissions on this. As I say, we're going to make fuller submissions in due course. And then we've got the evidence on the hotel's losses and the defendant's own losses, the claimant's own losses. Dealing with the claimant's own losses pretty quickly at paragraph 66, these are agreed at approximately 3.6 million. I've given the reference to the joint memorandum. I'm not going to trouble you right now to take you to it because that's an agreed position. The real dispute between the experts on the losses here, this is Mr. Millington and Mr. Levine, is whether GOP, gross operating profits, or NOP, net operating profits, is the appropriate measure. We say it's GOP because that truly represents the losses of the hotel, which is the owner's losses. Ms. Levine says, no, you need to look at the net losses because she says there are costs that need to be deducted. Again, it's a matter of debate between the experts to be examined in due course. There are some other sub-issues like seasonality and comparisons with other hotels, but they may be of less importance at this stage for the opening, perhaps, but will be dealt with in evidence. My lord, that should be an outline of the case and indeed the claimant's position in brief. Unless there's anything in particular, my lord needs to hear submissions on those. That's the opening.
Yeah, that's helpful. Thank you very much. Yes, it helps me understand the nature of the evidence to come. As I say, I would be grateful though for your joint help in just a list of the issues and where the claim and the answers to the claim are to be found in the pleadings.
Yes.
Thank you very much.
Thank you.
Thank you very much for that. Mr. Carvelis, the timetable allows for a 15-minute break. Do you want a 15-minute break?
If I can, Your Honor, yes.
Yes, okay. So I'm just trying to keep this timetable in mind. Otherwise, I had a trial recently where everything went haywire right from the start. Therefore, it's important to try and stick to it. Okay, we'll resume now in, what time is it now? It's 9:16, okay. 9:30 UK time?
Yeah, 12:30 UAE time.
I think my learned friend was very helpful and we have already saved 15 minutes in the timetable.
I did say I'll try and save time.
We'll finish the case tomorrow then.
Thank you.
Right, thank you.
Thank you, my lord.
Good morning again. Mr. Carvelis, it's your turn.
Thank you. Thank you, Your Honor. Just a quick one. I was reminded by a learned friend that I missed one very quick housekeeping point, not controversial. Mr. Craig, our quantum expert, issued an addendum to his report last Friday, I think. Essentially, he reduced his quantum. I wasn't very happy about it, obviously. We communicated this to my colleague, my learned friend, and I think we are in agreement that it is part of the evidence.
Is that in the e-bundle already?
Yes.
Not yet.
Not yet. No, I'm just being told that it will be uploaded today, together with it will be uploaded soon.
Any objection to that, Mr. Costello?
No, not at all. Thank you, my lord.
Thank you very much. Very well.
Thank you. Your Honor, this case should be a relatively simple construction dispute. Project finished late, the contractor blames the employer for the delay, the employer blames the contractor for the delay, the engineer issued a determination, agreeing with the employer on the basis of the determination. The contractor disagreed with the determination and commenced proceedings. That's how it should be. Unfortunately, it is not. Unfortunately, it is a case of miscalculation, spite, and treachery. And let me explain what I mean by that. Let me start with miscalculation. As I mentioned, the engineer issued a determination on the 5th of March, 2020. You will see this in the chronology. I should say that I will try to keep it short and not use the entire 1 hour that is allotted. After all, I will need a little bit of time with Mr. Akiki, but unfortunately, Reem's case is bigger than 5, so I can't promise I can do it. I will do my best. I will first give you a little bit of the background of the dispute as we see it, and then briefly we can look at the skeleton arguments that we filed, perhaps which summarizes the case. So, as I was saying, this is a case of miscalculation, spite, and treachery. Miscalculation for the following reasons. Engineer issued his determination on the 5th of March. The defendant gave a notice of, Reem gave a notice of dispute on the 9th of March, immediately after. And on 15th of October, 2020, we are in 2020, the defendant issued a demand payment notice. Now, I'm not sure if Your Honor is familiar with the proceedings before onshore Dubai courts. There is a process which is to an extent similar to summary judgments before the IFC and UK courts, which is called payment order. This is a process which is limited only for debts, for monetary debts. It is an ex parte process. It starts with an ex parte application and presupposes that the claim, the debt, is immediately evidenced on documents. There is a documentary evidence immediately showing that the value of the debt and that it is due and payable. The first step for such an application to be made, which, as I said, is an ex parte application, is that the creditor must first summon the debtor formally, issue a payment demand notice. This was made on the 15th of October 2020. The moment it was sent, 5 knew, and it is impossible that they did not know, that Reem was intended to commence proceedings, payment order proceedings, before Dubai courts. Why Dubai courts? Because the language, it is not an issue in this trial, but it is, in our view, very relevant for the conduct and intentions of the parties, because the dispute resolution clause of the subcontract uses the language which the Supreme Court of UAE, Dubai, and both the Supreme Court of Dubai and the Supreme Court of Abu Dhabi have repeatedly found that the reference to the courts of Dubai is a reference to onshore Dubai courts and excludes the IFC courts. On this basis, the Reem issued the demand notice and intended to file the proceedings, commence proceedings before Dubai courts. 5 realized it, and I suspect not for the first time in similar situations, they countered by commencing proceedings before the DIFC courts. On 27th of October, they commenced proceedings before the DIFC courts. Following the demand notice, just for the history, Reem made the ex parte application, which was rejected by Dubai courts because the court was not convinced that the documents produced, made available to the court in support of the application were enough to justify a payment order. Again, all this is irrelevant. I'm just explaining for the background. And then, of course, Reem had the option to appeal, and this time, as per the Dubai court proceedings, 5 would be invited. And at that time, it was more or less certain that 5 would challenge the jurisdiction of Dubai courts before the Court of Appeal of Dubai, as they were entitled to, argue that they had already commenced proceedings before the DIFC courts, and send the case to the Joint Judicial Committee. That was the purpose. Send it to JJC, hopefully take a couple of years to sort it out with JJC. They would probably lose, and they knew it, on the basis of the precedents in the civil law concept anyway, precedents of Supreme Court judgments, and because JJC was reluctant to allow tends to protect Dubai onshore courts jurisdiction than DIFC court jurisdiction, but this is an entirely different matter. The point is that this is why they commence the proceedings in DIFC courts. They do it in such a rush that they produced a claim form, which I have been struggling now preparing for the opening statement to find a term for this claim form. For the sake of, collegiate courtesy, I will say that it was ill-prepared and ill-founded. At that time, Reem had 2 options. A, continue before Dubai courts, and I will explain why the claim before Dubai courts was so much smaller than the not so much, relatively smaller than the claim before the IFC court. Fight the jurisdictional challenge that it was certain that 5 would do before Dubai courts. Fight the case before JJC, or accept jurisdiction of the IFC courts and fight the case before the IFC courts and remove 5 the option of delaying the process, especially with the Joint Judiciary Committee, which is exactly what Reem decided to do. It called the bluff, because this is what it was. It called the bluff of 5, accepted jurisdiction of the DIFC court, and proceeded before the DIFC court. What was the result of that? To start with, the claim of the initial claim of 27th of October 2020, whereby 5 commenced the proceedings before the IFC court, was struck out because it was so ill-prepared, so preposterous, that there was nothing else to do but strike it out. There was nothing left but strike it out. Reem filed a counterclaim before DIFC court. As I said, Reem's decision was to take the case, to try the chances before the DIFC court, and filed a counterclaim, a significant one. This time, because it was not limited by the requirements of the payment order process before the Dubai court, not anything, not for what was readily evidenced by documentary evidence as due and payable, but also other heads of claims that required scrutiny and substantiation. Hence, Reem's claim was much higher. This angered, and I think I use a very mild word again, 5. When they realized that they could not play their game anymore, and they had to deal with the claims of Reem before DIFC court, which court had already summarily and in very strong language dismissed their initial claim.
Mr. Karvelis, can you remind me, just in a word or two, what the nature of the Five's claim in the DIFC courts was, the one that was dismissed?
It is, yes, I can, and we will, you will see that it will be part of a discussion later this afternoon. Effectively, they claimed the engineer's determination. They required payment of the amounts that the engineer determined that they had lawfully deducted. So they had deducted 7-point-something million as a result of the engineer's determination, and they made a claim to the court requesting Reem to pay to Five this same amount, which they had already deducted. Delay damages, variations, omissions, to be precise, determined by the engineer, Contra charges, all these sum up to 7.4 million, if I remember, if I'm not mistaken, 7.7, 7.4, something like that, doesn't make much difference. The engineer, by the way, determined that following his determination and following the reductions, Five would have to pay to Reem 1.8 million. After all these deductions, recalculating the contract price and taking into account payments made, the engineer found that there was 1.8 million payable from Five to Reem. Five made a claim form to DIFC court claiming payment of 7.7 million of this exact amount. It was no surprise that it was summarily immediately dismissed. It didn't take much effort for Justice Fields to grant a strikeout order.
Yeah, thank you.
As I said, Reem made the counterclaim, so Five found themselves in a position, in an awkward position. They commenced proceedings, hence they are called claimant, and they found themselves as defendant as a result of the counterclaim, and then without a claim, it had been stricken out. They fought tooth and nail, as they say, to do anything they can to frustrate and delay the process. The latest application, which was heard by you, Your Honor, was application number 16, in a year and a half. Within less than 2 years, we reached application number 16 in relation to, I will have to repeat, a relatively straightforward construction dispute around an engineer's determination. And because they realized that this was not enough, they lost every single decision they made. They managed to win one for a few days, for a couple of days, because they misled the court, just as simple as that. They did not relay to the court the entire information that they had to do, and their application that was granted was annulled within 2 days or 3 days. This is the reality. And because they were in this situation, they were desperate to find something against Reem. So they made their own claim, new claim right now, which is now TCD 3, claiming the indemnity claim that my learned friend discussed earlier on, added another head of claim, which they had not before, their additional costs as a result of the delay, essentially. They added, that is, 11 million for the indemnity claim, another 7 million for additional costs and change. Simply, I suspect that the reason that these numbers are just numbers, nothing more than numbers. So to make sure that the number in their counterclaim, in their claim, is higher than what they knew at the time as Reem's claim. But we will discuss this later on with the various, well, with the three witnesses and experts of 5. This is what the case is about in reality. A fabricated claim at the end, entirely fabricated claim. They thought that it was a good opportunity, actually, that the loss that they made out of this particular investment would be recovered from the one contractor that had the audacity to take them to court. And again, I will explain this, and this will be discussed later this afternoon, what I mean by that. The entirety, so let's split between Reem's case and 5's case, Reem's claims and 5's claims. First of all, both Reem's claims and 5 claims are dependent on the findings in relation to delay. If you find that 5 was caused the delays, then immediately the entirety of 5's claims go away, they presuppose delay, and then it's a matter of quantification for Reem's claims. Equally, if you find that Reem was the cause of the of delay. Then its entire claim for prolongation goes away, for prolongation costs goes away. There are some residual heads of claims, omissions, what we call unlawful omissions, and contract charges, and unlawful contract charges would still need to be considered. And then it is a matter of legal and factual substantiation of five claims, the indemnity claim and the additional costs claim. So it is a matter of delay. And as I said before, we have an engineer's determination. Actually, the whole of Five's defense, both around delay and omissions, is on the basis of this determination. Actually, in one of their submissions, and I should have said, by the way, that at some point they desperately attempted, when they realized that their first claim was hopeless, they tried to amend it, very late, of course, and they were refused. And the amendment they used, the amendment was in reality, actually the claim TCD3, the particulars of claim TCD3. So they tried first to bring into the process as an amendment to their hopeless original claim. They failed, so no problem, we'll start new proceedings here. This is what they did. So in one of these now instances, as I said, there have been so many applications and appeals that I have lost count. They actually argued that the engineer's determination must be respected entirely. It is, I don't know, it is very precious, and if the court allows that an engineer's determination is challenged, the entirety of the construction industry in Dubai and the UAE is threatened. This is an argument made in one of the witness statements filed by Five in one of these earlier applications. I could show it to you if you want. I don't suggest that I do. I think my colleague will not disagree with me that this was actually said. But if it is disputed, I will be happy to show it to you, to guide you, to direct you to this submission. It predates, I must say, that these were submissions made by Five prior to engaging my learned friend, when they had a different form of representation in this dispute. So their case is based on the determination, on the engineer's determination. So what would one expect? What I would expect, actually, I would expect that the engineer would be a witness here. Nothing. He is not. Actually, what is striking in Five's entire defense and support of their claim is not so much what it is included, it is what is missing. First of all, the engineer. It is beyond, I cannot understand. I have had my fair share of construction disputes. I cannot understand how the party that relies on the engineer's determination does not make sure that the engineer gives testimony. Mind you also, Your Honor, that the engineer was not an individual, one civil engineer acting as the engineer of the contract. It is Atkins. It's one of the biggest engineering houses in the world, with a very big establishment in Dubai. Even if the particular individual who was the engineer in 2017 or 18 or 19 was no longer available, this happens. It was Atkins that they hired as the engineer, not the individual. Someone could have come and give evidence. There isn't. Second, there is almost no reference at all, and any reference made is passing and in a way to lower the importance that Reem was one of many contractors on the project, not even the main contractor. It was the contractor responsible for 7%, nothing before, nothing, no digit before, no digit after 7, of the entire value of the hotel, for the construction of the hotel. Now, arguably, a house is not finished until the front door is installed. And without the front door, which has a small value compared to the rest of the house, you don't have a completed house without the front door. I could understand the argument. The least I would expect is, it's a construction dispute, I repeat. They should have showed that every other contractor was done, because this is how they present the case. Every other contractor was done. They were all sitting idle and eager, waiting for Reem to finish. All this time they had idle personnel, labor, plant and equipment. They accumulated claims against 5. They made the claims, and now 5 was determined to recover this loss from Reem. I thought I'd see this. There is nothing. There are very few passing references to the other contractors. I submit to you, not by mistake. It is not an omission. It is not something they missed, they forgot to do. It was intentional. And we will see why it was intentional. The other, what other is missing for 5's case, both the defense and the support of the claim, is evidence. Evidence. The documents mentioned, referred to during the very few submissions, are nominal, very few. The documents produced during the document production was for a construction dispute, very, very thin. Again, that's the mildest expression I can think of right now. Very thin, very few. And nothing that provides actual evidence. They criticized. Actually, Mr. Akiki was very proud of 5 using very many different project managers. You will have seen it in his witness statements that he is very proud that 5, when they took over the works, they used many project managers. They split the floors of the hotel amongst various project managers, and actually criticizes Reem because they had one project manager for the entire building. And the only factual witness they trust as a witness is their CEO. No one else. None. Again, their CEO. And then, as I said, it's a construction dispute around delays. Again, in the few constructions disputes that I've seen, that I have worked on, I always dread the time that I will have to cross-examine a delay expert on a delay analysis. They speak a language that I cannot understand very often. There is no delay analysis here. Their defense, their whole case is around a delay, the delay, and the delay analysis that they say it is to be relied upon is not by the expert which they hire, which they instructed, it is by their CEO. As to their claim, if you find it useful, we can look at the skeleton argument. As to their claim.
Which skeleton are we looking at?
The skeleton, our skeleton that we submitted last week. That we filed last week.
Your skeleton.
Yes, our skeleton.
Okay.
I said, but before we go there, one last thing about their claim, which is also what is missing, but their claim and their defense. They say that they have an obligation as claimant, as 5 real estate development. This particular entity has a liability towards another entity. Right? This is what they say. The owner, Unlimited One, has a claim against them. The least they could do is join owner one in this dispute. They did not. They also say that there is in relation to the fire incident related prolongation costs, we should first go to China State, and China State will have to pay, and if China State does not pay, then they will deduct. We will see 4.5 in detail. They will deduct from payments to China State whatever it is to pay to Reem. In other words, China State is liable against 5 for any payments that 5 will have to make to Reem. Otherwise, why would they deduct from payables to China State? Where is China State again? They could have joined China State. The rules of the court allow the joining of third parties if the cases are related. You may recall that they threatened to do that in an attempt to avoid the disclosure of documents which we requested them to produce. They should have, actually. It's not that they should threaten, they should have done this. If they were of the view that it is China state which is liable, and it is China state that can defend realistically on whether Reem discharged or did not discharge its obligations for notification of its claims to China state, they should have joined it. Effectively, what they do is they chose to defend themselves, the owner, and China state. If we can look at briefly, because I'm conscious that its document, it's B23, Your Honor, in the bundle. It's our skeleton argument.
I don't have the page numbers on your skeleton because it came in after I copied it, but don't worry, I have the skeleton.
No, I can use the paragraph numbers if that's more helpful.
Yeah.
Paragraph 7.3. Let's start from paragraph 7.3.
Yeah.
I said before, a hotel, well, self-evident. It's a big project. The value for the hotel is 680 million dirhams. We know that because they told us. 5 told us that it is 680 million. They have not disputed it. 680 million, to put it into perspective, is what? 150 million pounds sterling? Thereabouts, but between 150 and 200 million pounds sterling. It's a big project. May I remind you, Your Honor, the value of the works, of Reem's works, was 47 million dirhams, hence 7%. Now, as a big project, it included a lot of contractors. You can see a list of those contractors in paragraph 7.3. Mind you, Your Honor, that these are the subcontractors, not the main contractor. You have to add here the main contractor, China state. Now, again, a bit of background here. As my friend mentioned earlier, Five issued a work order to Reem on 19th April 2016. We will see if they worked before or after. When did they start working? That's not the point here. What is normal, what is the standard, is that the glazing, aluminium glazing subcontractor is a subcontractor of the main contractor, just as everyone else. All those in the list in 7.3 of our skeleton arguments are subcontractors of the main contractor. Reem was not. Reem was initially engaged directly by Five. Five issued the work order, not China state, not the main contractor. Reem and China state commenced negotiations for the subcontract because the work order did mention that a subcontract would be required to be entered into between Reem and China state. But the fire incident occurred, the negotiation, the subcontract became much less a priority for China state and Five. And at some point, for a very good reason, good for them reason, 5 decided to scrap the agreed and standard structure of projects. And instead of having a main contractor with various subcontractors hanging underneath the main contractor, engage directly all subcontractors, all of them. They use novation. It's not a concept which is a UAE law concept. What they mean by that is assignment of rights and transfer of obligations, which is the equivalent of novation, but it's not novation. There's no such concept in the UAE law, but that's what they did. They took over, they stepped in and took over all of the subcontractors so that they manage. They manage them themselves. So any subcontract between Reem and China State was now redundant. And they entered, because there wasn't any contract other than the work order, which was obviously, you will have seen it, very limited, they entered into the famous subcontract, which we will discuss. As you will see, the works commenced. An important element here was the fire incident, obviously. It changed everything. It was a project that started at a bad time for the real estate industry. And that's my view of it, my opinion of it. In the UAE, the market was going down. And at the same time, the fire incident occurred. Fire incidents like this attract a lot of attention to the UAE. Unfortunately, or fortunately, so everything that could go wrong to this project did. They decided to take over the project and manage it themselves. I suspect. We will see. We will ask Mr. Akiki why they did that. What was the main reason for this? The works did not proceed since the recommencement did not proceed as they should. There were delays. Five's own and sole factual witness / delay analyst was very gracious to accept that there were no delays attributable to Reem before 19th of March. So everything else is, any discussion before that is, which I would be happy to do, but it's redundant now. There's an admission here.
19th March, what year?
2019.
Yeah.
So what he himself calculated their entitlements for the period 19th March, for delayed damages at least, from 19th March to 2019 to 2nd of September 2019, when they eventually conceded that the hotel opened, and they had to concede this eventually. They did not at the beginning, although it was a matter of, undisputed fact. There were guests in the hotel that were in the hotel on the 3rd of September. It should be relatively easy to accept. From 19th of March, there were delays, all caused by either Five itself or its other subcontractors. And there is documentary evidence to this. Unlike the lack of any documentary evidence, trying to show, it is a very novel argument which I haven't come across very often in construction disputes, that what they're saying is that although up to 19th March 2019, 15th March 2019, Reem is not responsible for the delays. It was other contractors' delays. Nevertheless, Reem was late before that, and as a result, they did not finish the works that they did from March to September in time. This is the argument that they made. On one hand, there is no liability for delays prior to 15th March, but then on 15th March, Reem was not in the position to complete the works immediately. What they're trying to say is that although there were delays, they say that there were delays between 15th March, these delays did not affect Reem at all, and on 15th March, Reem should be ready to finish everything within 12 days. This is what they say. And they say that whatever happened after 15th March and until September, late handover, i.e. late access to site, late handover of floors to do the work, were all the result of previous delays of Reem, for which, however, they don't hold Reem liable, because up to 15th of March, Reem was not responsible for the delays. I have been trying to understand the argument to the point, after a year and a half, I struggled to get this argument, how can this work? Regardless, by the way, of the actual documentary evidence on record, which, amongst other, my learned friend tried to refer to earlier and tried to dispute in his skeleton argument. The facts show that as late as August 2019, 1 month prior, a few days prior to the opening of the hotel, they issued another variation. They issued a variation, and they issued a variation for the replacement of glasses broken by other contractors. You know, Your Honor, if one wants to really understand Five's claim, if you can bear with me for a moment, I'm trying to locate one particular document. The entire case of Five can be understood if one reads just 3 paragraphs in Mr. Akiki's witness statement and 1 paragraph in my learned friend's opening skeleton argument. We will discuss it later on, but if you can go to the third witness statement of Mr. Akiki, paragraphs 32 to 34. It is pages E1792 and Echo 1793 of the bundle.
Do you want me to read those?
Not necessarily, Your Honor, but we can do it now. Let me make my point, and then if you want, we can go through it. This is 3 paragraphs. It is a very simple issue, you know. There were glasses broken. The hotel, the balconies had a glass rail, a balustrade, as they call it. It's glass. There were works there, continued works by many contractors. It's glass, it will break. It is indeed quite common to have broken glass, and this glass will need to be replaced. If it was broken by Reem would have to replace it. If it was broken by 5 or any other contractor working for 5, Reem would have to replace it and get paid for it. It is 3 paragraphs where Mr. Akiki is trying to explain, A, that this very simple fact is not as simple as everyone would see it. It's not as simple that if someone breaks something, that he has to pay for it. He takes 3 paragraphs, and in order to justify that they gave a variation order 1 month prior to the opening of the hotel, his defense is, and I will read from it, I had no option but to bow down to the unreasonable demands of the defendant to avoid any further delays in the project. And that Mr. Al-Mahdi, the Reem's project manager, what I read is the penultimate sentence in paragraph 32. Then in the first sentence of paragraph 33, Mr. Al-Mahdi was a master in ensuring that his unreasonable demands. That's how they paint themselves. This is their case. The weak, ignorant developer who fell victim to the viciousness of of the glazing subcontractor, the subcontractor who installed the glasses in a 680 million project and left them broke. And they could do nothing but bow down to the unreasonable demands of the defendant. And then, which is now directly relevant to the absurdness of their own fabricated claim, it is in paragraph 55 of my friend's skeleton argument.
Yeah.
This is, to put it into context, this is the section of my friend's skeleton which deals with the indemnity claim, the claimant's losses and the indemnity claim. And here it discusses a couple of, well, one UAC law article, and then in paragraph 55, you will see the second sentence, which is the following. The defendant's argument in its defense to the claimant's claim do not render the contract unenforceable, here it is, as the commercial arrangements between the parties are a matter for the companies. Now, the commercial arrangement between the parties, I suspect he means the parties to the famous property development agreement, contract, how they call it, i.e. 5 real estate development, the litigant, and Unlimited One, the owner. These are the parties that my learned friend refers to, and they are also the companies. So basically, my friend, what he's saying here is that whatever Unlimited One, the owner, and 5 real estate development agreed between themselves, Reem must take it for granted. It's a pill that they have to swallow, as is, and there's nothing they can do about it. This is their case. This is how they developed their case. This is Mr. Akiki's witness statement, and this is how Mr. Millington tried to quantify. It does not matter. You don't need to know. You, Reem, do not need to know what really happened between us. You, Reem, do not need to know if and how much I lost. I tell you that I lost 11 million for gross operating profit. That's it. There's nothing you can do about it. You have an indemnity clause. And one last point, because it's a legal submission, which we will, of course, develop it in the closing submissions, but I think it would only be fair to make it now. There has been a lot of discussion, and there will be a lot of discussion about clauses 4.5 of 4.10, excuse me, of the contract between Reem and 5. It is the famous indemnity clause. And clause 8.1, which is the famous delayed damages clause.
So basically, clarify here, sir. Now the court,
Martin, I think you are on. Oh, you're not muted.
Wasn't me. This is not. I wasn't talking.
Sorry, I'm not sure who was talking.
Yeah, I
The
think
background.
it's okay. It's gone now. All right.
Yeah, apologies, Your Honor. Let me recap first. Reem claims prolongation costs,
Yes.
omissions made unlawfully, contract charges made unlawfully. These are the heads of claims, plus financial charges, interest. These are the heads of claims for Reem. 5 claims to uphold, of course, the engineer's determination. Apologies. 5, Reem also claims the amounts deducted for delayed damages. So to sum up again, delayed damages unlawfully deducted, omissions unlawfully deducted, contract charges unlawfully made, all these by the engineer, and prolongation costs not determined by the engineer. These are the heads of claims for very simple. I told you from the beginning, it's a simple, relatively simple construction dispute. 5 claims, everything that the engineer determined that they are entitled to deduct, delayed damages, contract charges, omissions, and on top of that, so it's a sort of a declaratory relief, if you like, or a defense in Reem's claim, and on top of that, they claim indemnity claim, the indemnity claim, i.e. the losses of the owner of the hotel, which they try to pass down to Reem, plus extra costs suffered by the claimant, 5 real estate development, as a result of the delay by Reem. But this time now for a period which goes before the period of delayed damages. Not for the period 15th March to 2nd of September, the 170 days, they insist that Reem was liable for the delay, caused a delay. But even before that, it starts in October, when the work should have first been completed. These are plus change for defects, for changes that they instructed, by the way, for changes in door handles that they instructed. We will discuss this with Mr. Akiki and Mr. Law. These are 5 claims. Now, the way I understand it, and in the context of the UAE law, there are certain principles that cannot be ignored. A, the judge assesses compensation on the basis of actual loss. This is, and I'm sure that my friends will agree, this is in Article 387, I think, of the UAE Civil Code. The parties are allowed to fix damages in advance, 389 of the UAE Civil Code, for example, delayed damages, but the judge, in all instances, is entitled to revise these prefixed damages to be commensurate to the actual loss. The agreement, the indemnity agreement as such may be valid as an agreement, as a clause in the contract. Yes, pacta sunt servanda is a principle that of course applies in the UAE and in every other law that I am aware of, and it is reflected in the articles of the UAE Civil Code. How this is quantified, though, this entitlement, if liability arises, how it is quantified, it is an entirely different issue, and it is not dealt with within the indemnity clause. The provisions of the law must apply, i.e., actual loss. Now, though, there is another issue here, because I agree with my friend that the agreement of the parties must be respected. They agreed, the parties agreed, incidentally, in a contract proposed by 5. They were the ones that proposed the actual draft of the contract. They provided for delayed damages, i.e. they fixed the damages in cases of delay, and then they added the indemnity clause. Immediately there is an issue here. Unless the ambit of the 2 clauses is separated, i.e. unless 4.10, the indemnity clause, applies in anything but delays, then we have a direct conflict between the 2. And if we have a direct conflict, I submit to you that special prevails general. 8.1 is a special provision, especially for delays, therefore it prevails over 4.10. In my view, there is no need to do such an elaborate and difficult exercise. I think they have a different ambit. 4.10 is intended for losses that have to do, for example, it would be the basis for defects, over and above perhaps also the retention or what the defects, whatever the contract says about defects. In case of an accidental destruction of part of the property, that would serve then the indemnity clause 4.10 would serve as the basis. Everything that has to do with delay are associated, are under 8.1 of the contract, the delay damages contract. They fixed the damages for delays. But if this is the case, then A, if they win the delay argument, if they win that Reem was responsible for the delays, they have themselves quantified their loss. It was 7 million, and again, Mr. Akiki was gracious enough to reduce it to 2.9. And they have deducted 4.5, the delay damages. So we have the actual loss acknowledged, admitted. The judge is entitled and requested by us to reduce it, to apply 390 second paragraph and reduce it, and reduce the fixed damages to the actual loss. If it is not, if these are not delay claims, they have to prove it differently. But they say it is delay. They argue that these are delay claims. If they lose the delay argument, then they cannot claim it as delay. So, to summarize, Your Honor, it is a construction dispute at the end of the day. It is a matter of whether Reem did or did not, was not allowed to perform their works efficiently, to use the English law term, was prevented or not, whether there was prevention or not, caused by 5 or by other contractors. We submit that the evidence is entirely on the side, documentary, contemporaneous evidence, all of it, or to be precise, the majority of it produced by Reem itself is on the side of Reem. If this goes away, if delay is found, if the delay issue is found in favor of Reem, then I don't think there is any other discussion in relation to the claims of the remaining claims of 5, which are all connected at the end of the day to this. Notwithstanding, 5's claims are at best preposterous. They should be struck out, and I must admit, Your Honor, we were tempted to make an application to strike out after the evidence we saw, or the lack of thereof, including Mr. Millington's report. We were tempted to make an application for an immediate strikeout of TCD3. We opted, for better or worse, that we should not delay the process any further. We should continue with the trial. All this will be, if they're not already, they will become evident over the course of these few days. And at that point, Your Honor, you have discretions under the RDC rules, which you may or may not exercise. Thank you.
Thank you very much.
I hope I wasn't too late.
Well, thank you very much. The next stage is Mr. Akiki. Do you want 5 minutes to get him organised?
Yes, yes, my lord. He's currently, I know, on the call, but actually, we can just use this quickly, just 1 minute of our time, just to discuss one thing. I know that everyone was present for the openings, but I suggest now that we're into the evidence stage, where the contentious matters really begin, that really Mr. Akiki should be on the call, and my learned friends witnesses shouldn't be on the call at all to hear his evidence. The experts I'm more flexible on, because I think they've got their duties to the court are slightly different. So I'm content for the experts to stay on, but I submit that my learned friends witnesses should not be on the call when Mr. Akiki gives evidence.
What do you say about that?
If I may, Your Honor, it's a trial, it's not an arbitration hearing. And trial is open court. I'm not sure I saw anywhere in the rules that witnesses are excused, but it's up to you. It's entirely up to you.
Yeah.
For experts, I would agree with my, not only I would agree with my learned friend, I would also add that it is useful if we have them on board, because you never know, over the course of the next 2 or 3 days, any of them can have a change of mind. And the beauty is to you.
If there is, unless there is a practice of the DIFC, and I'm not aware of it, then I would be prepared, I would be minded to allow fact witnesses as well as experts to be present during the evidence. But Mr. Koshdell, is there any practice of the DIFC court that you can draw to my attention? I should say that in Scotland, where I've been a judge, the rule is that witnesses do not attend the other evidence, but in England they do.
I've seen it sometimes in England where they're excluded as well, from my own.
Usually only if there's some particular reason.
Yes, it's only because there are some there's some matters of evidence which is not only hotly contested but subject to interpretation one way or the other. But can I just say this, if I may? The particular reason is that Mr. Akiki, of course, will not have a reply opportunity, whereas if his evidence is heard, then the witnesses from my learned friend of fact would have had the benefit of hearing his answers, and you know, they will know what his position is, and that's the reason why we make this application.
But that assumes they won't be told the answers anyway.
Well, I know my learned friend won't, and I'm confident that
there'll be nothing improper with asking the witness before they give evidence. Or Mr. Akiki says that. What do you say about that?
I
hear it direct.
Yes. Well, I hear what my lord says. I've made the application, but so be it. Mr. Akiki is online. He's available to give evidence. I don't know if we need any short break beforehand or not.
It says have two minutes and then resume in 2 minutes' time.
Certainly. Would you mind if I just switch my camera off quickly and then I'll... Oh, I think it's gone. Okay.
No, of course. Turn your camera off. Yeah.
Sorry. Thank you, my lord.
Yes, Mr. Cocktail.
Yes, thank you. My lord, I call Nabil Akiki. So, if Mr. Akiki, can you switch on your camera, please, for us?
Sure. Good morning, Lord. Good morning, everyone.
Good morning, Mr. Akiki.
Sorry.
Yes, I'll ask the court staff to administer the oath, please.
Thank you, Your Honour. Good afternoon, Mr. Nabil. Would you please state your full name and occupation for the record, please?
Yes, sure. My name is Nabil Akiki. I'm the CEO of the claimant.
Thank you. Could you please confirm if you will be taking an oath or an affirmation?
I'll take the oath, please.
Thank you. Could you please confirm if you have a hard copy of the Holy Book in front of you?
Yes, I do.
It should be visible.
Yeah.
Thank you very much. Would you mind placing your right hand on the Holy Book, please?
Sure.
Please repeat the statement after me. I swear by Almighty God,
I swear by Almighty God,
what I believe and to say the truth,
what I believe and to say the truth,
the whole truth and nothing but the truth.
the whole truth, but nothing but the truth.
Thank you. Thank you, Mr. Akiki.
Thank you.
Thank you, Mr. Costello.
Thank you, my lord. Could you just confirm your full name again formally for the court?
Yes, my name is Nabil Akiki.
And I can see there are two individuals in the room with you. Can you just confirm who they are, please?
Yes, they are Buhan and Kate. They are assisting me in the hard copy of the bundle.
And can you just tell us who they are in terms of titles or job titles, etc.?
Yes, they are employed with the company, dealing with all the document control system and the documentation.
Are any of them in the legal team?
Buhan is in the legal team. Yes.
And Miss Kate?
Kate, she's a secretary.
Okay. Now, I've paused because Mr. Carvelis wants to say something.
Carvelis.
I'm afraid I have to. This is not according to the protocol, and I could understand if someone assisting with Mr. Akiki with the bundle might be necessary, although I'm pretty sure that my friend will make sure that the documents are projected on screen, and I see Mr. Akiki uses a small camera close to him, so he will be able to see it on his monitor. And definitely, I believe one of the two individuals is part of the legal team of 5, and that would be highly inappropriate.
Mr. Costello.
Well, both individuals, let's just say they weren't in the room, could log on to the hearing. It's a public hearing. They could hear the evidence. If my learned friend is suggesting that it's inappropriate because they may speak to each other, they're all on camera as we see right now. The microphone is audible, and I'm perfectly happy to display my own computer screen if that assists my learned friend in order to see what Mr. Kiki is looking at in terms of the bundle. But I don't understand my learned friend's objection in reality.
Do we need 2 people to help with the documents?
I'll
If there's a non-legal secretary, I don't think the objection would be so forcefully put. The concern is that in some way, if someone in the room is part of the legal team, it can influence or maybe influence some response. Whereas a secretary who is not part of the legal team, I don't think can be objectionable.
So in which case, the Mr. Buhan Puri, who is part of the legal team, he would have to leave the room.
Yeah.
I think that's better that way. Let's keep as close as we can to the protocol.
Okay.
Mr. Carvelis, you don't object to the secretary being there to assist you? No, thank you.
And I should say, Mr. Kiki, we can see we can see you, and we can see on the top above you.
Yes.
What looks like a 360 view of the room. Is that?
That's correct. I mean, this is a tower camera that can take panoramically all the room. So there is only one door, which is just where he left Buhan, and there is no one else in the room. But however, the walls are glazed, so you might see some movement, but there is no hearing between here and the other side.
Okay. All right. Thank you. You've confirmed your name, and you have said your job title, but you are the Chief Executive Officer, aren't you?
Yes.
For 5 Real Estate Development.
That's correct.
LLC, yeah. And whilst there are 3 witness statements that have been uploaded, in fact, I'm going to ask you to confirm 2 of them for me. The first one, in fact, what I will do is I will share the screen on my other laptop. If you just bear with me.
No problem.
Okay. Right, this is what we have termed Nabil Akiki witness statement number 2, my lord. It's at E372 of the bundle.
Yeah.
And Mr. Akiki, can you see that this is your witness statement?
Yes, I can see.
This is a witness statement which consists of, I'll get to the end, 26 pages,
Yes.
97 paragraphs, and there are various exhibits that were exhibited to this witness statement.
Yes.
And can you confirm just below the statement of truth, is that your signature?
That's my signature, correct.
And it's the 24th of March, I think, 2022, the date?
24/3/2022.
And can you confirm the contents of this witness statement are true?
Yes, I do.
Thank you. There is also a further witness statement I would like you to look at. This is this is called witness statement number 3, E1782 of the bundle.
Yes,
Again, is this your reply witness statement?
that's correct.
And just so we understand, this was a reply witness statement to Mr. Al-Mahdi's first witness statement and Mr. Harish Nair's first witness statement.
That's correct.
This is a witness statement consisting of 19 pages, correct?
Yeah.
51 paragraphs. Yes?
Yes, that's correct.
And it had exhibited one exhibit to this witness statement, cumulatively 46 exhibits.
That's correct.
Again, we have the statement of truth, which is, you can see on the screen at the bottom, page 18, and a signature underneath that. Do you see that?
I can see that.
And is that your signature?
That's my signature.
And
Confirmed.
that's, yes, and dated the 5th of April 2022.
That's correct.
Again, can you confirm the contents of this witness statement are true?
I do confirm.
Thank you very much.
Thank
Now,
you.
I'm going to ask you just, I'll keep the screen on share for the minute, but I'm going to ask you just a couple of questions just about you, just to introduce you. You are, as you say, the chief executive.
Mr. Costello, do you need to keep the screen on share?
No,
Otherwise, I can't really see the witness.
sorry. Thank you very much.
you.
Yes, Mr. Akiki, just briefly, how long have you been with Five?
With Five since 2012.
Mm-hmm. And you've outlined in paragraph 4 your own personal background.
Yes.
In terms of with Five, what just tell us some of the projects you've been involved in.
Well, we started with 3 developments in Jumeirah village. They were residential G+4 buildings. Then we did the 5 hotel, which is at Palm Jumeirah, where the defendant was one of the subcontractors in this project. And then we moved to JVC Jumeirah village, the hotel that it's subject to this case.
And with the 5 Palm Jumeirah, was China State involved in that?
Yes, in both projects, in 5 Palm Jumeirah, China State was the main contractor. Okay. And in JVC, at the beginning, they were the main contractor. And then there are some developments that took place after the fire incident, which we will, I'm sure we will touch base on this later.
Yes, okay. Now, I'm going to just ask you a couple of questions, if I may, on Mr. Spawley's report. I'm going to open it up and put it on the screen for you. My lord, it's at G, it starts on G1674. Is that on, should be on screen now. Mr. Akiki, I know you have familiarity with Mr. Spawley's report. Is that right?
Yes, that's correct.
You'll recall Mr. Spawley makes comments on the defendant's delay analysis and also on the claimant's delay analysis. Okay.
Yes.
Now, I'm not going to ask you questions about his opinions on each delay analysis. I'm going to just ask questions on what he calls the 3rd period of delay, and in particular, the material that he deals with here. Can you see the 5 on screen at paragraph 199 at page G1715?
Yes, I can see that.
Okay, so first is the handover documents, and these I think were exhibited at LS 22. Okay, and what I'll do is I'll quickly show you that.
Thank you.
So this is, now this one is dated the 9th of June. Can you see that?
Yes, I can see that.
Whose signature is that?
Sorry, can you go a bit slower for a second? What page is that?
Oh, sorry, G2929. And my lord, just the document is the working space handover.
The working space handover. Yeah,
You see that?
I can see that.
Now this deals with grid T4 to T5. Can you see that? Yes, on the screen.
Yeah, I can
Just
see
tell us
that.
what does that mean in basic terms?
This is a format between the site management team that they are deployed from our side and between the subcontractor, which is Reem, if I'm not mistaken. Can you please scroll down to see again, because I don't recall whose signature is that. So this is received by, yeah, name and date, issued by, I honestly don't recall or remember whose signature is this, but definitely is not mine.
No, but does it look? It looks like it might be from 5. Is that right?
Yeah, it should be from 5, but we had many engineers on site, and every section there is one section manager we call, but I don't recall whose signature is this.
Okay, now we can see the date there is the 9th of June 2019.
That's correct.
And it deals with T4 to T5 for floors 41 to 59.
Yes, that's correct.
Just in brief terms, what does this I'll let you read the document.
Yes.
And then I want you to explain to the judge, to the learned judge, what this basically says and what it means in the context of this case.
Yeah. So this is the external balustrade cover and sealant. This is the topic of this document. Received by Reem and handover form. This is issued by 5. Then the description regulation. Number 1 is previous subdivision work has been completed. Number 2, its edge and opening protection has been completed by China State Safety. And then number 3 is the extra material has been arranged and stored properly. Number 4, garbage has been cleared and collected to appointed location, structural clearance received for area. So this is a clearance form that the area is ready, it is safe, it is clean, there is housekeeping done for the work to start.
And which work in particular?
Yes, we will continue to the remarks if you don't mind. So bottom rail cover protection during subsequent works happening in the location is responsibility of concerned contractor and should be monitored by 5. Any damage which might happen to the boarding or finishing, if applicable during rectification of area damaged material, will be provided to 5 for back charging to concern. So it is dealing with the cover of the outside cover of the plinth of the balustrade. So as simple as that.
So where it says here subdivisional work, external balustrade covering sealant.
Yes.
Can you tell us at what point is this work done in terms of the sequence of works?
This is the last bit. This is after then the concrete is there, after then the channel which is holding the balustrade is placed, after then the grouting is done, after then the glass balustrade itself, it is in place. This will come at the last stage to just put the last cover, which is an aesthetical cover. It's not a structural, it's only for the aesthetic. So this is dealing with that cover.
And is this before or after the eaves contractor?
It is after.
Okay. Now, as we said, this particular document looks at is dated the 9th of June. There is another one, G2934, Okay, so this is again another working space handover document.
Yeah.
I'll just wait for my lord to get there as well, sorry.
I have,
Oh, thank you. This deals with grid T6 to T7.
Yeah.
Yes. And this, again, levels 41 to 59, same work, yes, balustrade cover and sealant. This time, this is signed by, again, the same person, it looks like, who signed the first one,
Yeah.
but dated 23rd of April 2019, yes?
Yes, that's
It's
correct.
also, and it's also signed by Mr. Nair, dated 23rd of April 2019.
Yeah, that's correct.
And I'll be correct if I'm wrong, but this is the earliest of the handovers, and the 9th of June, which is the one that we looked at the beginning, is the latest. Isn't that right?
Yeah, that's correct.
In the context of the delay analysis, what does this mean? What do these documents mean or show?
In the context of delay, which delay, if you may specify, please?
Well, obviously, 5 is saying that Reem was in delay. Reem is saying that it wasn't in delay because the clearances were submitted late. So I'm asking you in the context of delay, analyzing the delay and where the fault lies. This is your opportunity to give your comments based on these documents.
Yeah, this is an extracted portion of the work, which is at the end of the phase of the installation of the balustrade. So the way how I look at it, it's only extracted for a particular area. It's not the overall work of Reem, which involved not only the covers of the aluminum of the glass balustrade, but also the curtain walls, the doors, and many other items. So in particular, this one, for me, it's a clearance to put the last cover from Reem side. It means any work which is before this has been completed, done, and that's the last clearance to go and put the aesthetic cover plus the sealant at the glass balustrade. So in terms of delay for this particular thing, I would say all the work has been done and they took place before the date of clearance to put the last piece of the cover.
All right. Thank you for that. I'm not going to ask you further about this document. You may be asked later, but I'm going to move on just again to deal with the next piece of evidence. These are the text messages, which I think you have seen before.
Yes, I have seen that.
My lord, this is page 2941.
yeah,
And it goes to 2951. I suspect you're going to be asked in more detail about these text messages, but just very briefly, what do they show and where do they fit into the whole context of delay?
Yeah. So I went through these messages, and remarkably, there are two floors in particular, level 39 and 40, if I'm not mistaken, but what I can see now is 39. And these two floors, they are the technical floors, which they have been used for the hanging of the lower cradles part of the building, and to park the upper level of the cradles of the building. So level 40 is receiving the cradles and its parking zone from the upper level, and level 39 is the place where the cradles they were hung to service the lower level. So the cradles they have been provided as per the contract by 5. So we have a subcontractor who did the cradles, and we give them to Reem to execute their works. So these are the access to their works. And these messages, they are dealing with the last floors after removing the cradles and giving clearance for Reem to go and install the last balustrades, which are related to level 39 and 40. So in the context of the delay, this date could have happened much more earlier if Reem they would have finished their work at all the other levels, which are below 39 and above 40, up to the level 59, which is the last level. These access could have been given to Reem much more early if the cradles they were able to be removed earlier. And why they were not able to be removed earlier? It was due to the delay that Reem have encountered in finishing the other parts of the building.
Okay. So just just to make sure it's understood and nice and in summary,
Yes.
you're saying that that Reem's delays earlier affected the access to 3940 because the cradles are needed for other floors. Is that what you've just said?
That's correct.
And could they do the works to 39 and 40 with the cradles still attached?
No, it's not possible, because to fix the cradle, there is a concrete parapet which should not be there for the hooks. Yeah, exactly. So if you see this one, you see the floor is without the concrete upstand. There is no parapet there. When the cradles are hooked to the floor, to the slab, there is no way that the main contractor can do the upstand. So the cradles has to be removed, and then the parapets, the upstand, the concrete should be done. And then after that, the clearance will be given to Reem to start installing the glass balustrades.
Okay, understood. So just so my lord knows, this was page 2942, and it's a WhatsApp message from the 27th of April 2019 that you just used as an example to explain that. Okay.
That's correct.
All right. Next documents, which are the work inspection request logs, page 2952, and we have to, in fact, I think this is already open. You have to click on the hyperlink to download it. And here it is.
Yeah.
And now again, so just briefly, what is this? What is this document?
This is RIA, which is the Reem. This is the abbreviation of Reem, inspection request log, aluminium and glazing work. So these are the work inspection log. So the list of the work inspection issued by Reem to the engineer.
And what is a work inspection request log? What does it show?
This is when they finish a certain task, Reem, when they execute one task, either it's a balustrade or one zone or balcony or terrace. So they raise an inspection to the engineer. So the engineer will come and inspect physically on site to see if this is approved, or it is approved with comments, or it is rejected to be resubmitted. So that's in brief the purpose of the work inspection request.
So we've got a list of a key, if you like, here where my mouse is currently. There, yeah, you can see that. We've got approved as noted, rejected, information record pending, resubmit.
Correct.
And it says as of 25th of June 2022.
Yeah, that's correct.
Now, we've got some dates here. 18th of August 2019, 18th of August 2019, where my mouse is scrolling over. It's the first two entries here.
Yeah.
And it says type SCW, which is thick curtain wall, correct?
Yes, that's correct.
And balcony bowel is balcony balustrade, is that right?
Yes, that's correct.
It refers to regularization. Do you know what any of this means?
Regularization of, I don't know, description, regularization of 10. I'm not really sure what does that mean.
Yeah, I'm just zoomed in slightly to make it easier to be read. All right, well, but we've got certainly here, we can see, let me see, I can show you. We've got the floor here, floor level 22.
Yes.
And then this is balustrade glass installation.
Yeah.
Which I don't think there's no objection to this. That is before, in the sequence of works, ordinarily before eaves is involved, correct?
You're saying that the balustrade glass installation should be before eaves? It's not correct.
It's not correct. Okay, you can correct me.
Eaves should be before the balustrade. But I mean, sorry, let's clarify. So if we are talking about the last cover, the last cover should come after then the eaves is installed. Yeah. However, if we are talking only about installing the glass balustrade itself, that's not related to, it can be installed before the eaves. So just to explain the two differences between installing the balustrade or closing it with the cover that we discussed 10 minutes ago.
Okay. All right. And we've got the key here, E. Can you see it says E?
Yes, I see that.
Level 22 received an E which means resubmit.
Yeah, which is a resubmit, correct. It's not accepted by the engineer, so they have to resubmit, correct.
And in fairness, it's also not a rejection either, because that's a C.
Yes.
Okay. So what ordinarily happens after a resubmit? What is the usual process?
They should complete the work and resubmit again, the same inspection for the same area, same zone, and raise it to the engineer once more, whenever they finish whatever is missing from this round.
Okay. Now, just a couple more questions on this and we'll be done, but I'm just going to sort, what I can do is I can sort it to show all of level 59, for example, here.
Yeah.
Need to zoom out slightly, but we can see here, that says 59, and we can go down and we've got 59, 59, all of 59 is grouped together.
Yeah.
Okay.
Yes.
And then we can come across to the description and look at what the work is. So for example, here, it says this is level 59, stick curtain wall glass installation, 27th of December was the submittal date, 29th of December was the inspection date, and it was approved as noted.
Yeah.
So that means it was accepted.
That's approved, and there is no problem with the installation of this particular part.
Now, when we come to the balustrade glass installation for level 59, the submittal date here it says 27th of December 18, inspection date 29th of December 18, and it gets an E.
Yeah. Resubmit.
Right.
Correct.
Resubmit. Now, we can go up to a later date. Again, we've got balustrade glass again for level 59. On the 2nd of March is the submission date, correct?
Yes, that's correct.
The 5th of March is the inspection date.
Yeah, 3 days after, yeah.
And it gets an E again.
Correct.
What does that mean?
This means that it is to be resubmit, and you want me to tell you a few background about what's the difference between rejected and resubmit, if I may.
Very briefly, I think, if it would assist.
Yeah. Rejected if something is installed wrong. For example, the balustrade is not in the right place, and it has to be removed fully and reinstalled. The resubmit, it means the work is not completed. So if the engineer will go and see that there is part of the work done, part is not done, so they ask to resubmit. That's okay.
Fine. Now, in terms of level 59, the final entry we have was the 2nd of March for balustrade glass installation as it goes. There isn't a record of anything work done after level 59. Do you see that?
Yeah, I can see that.
But it doesn't necessarily mean, does it, that the work wasn't fixed and then resubmitted later? Is that right?
Yeah.
It just means there isn't a log, that's all.
Yes, correct.
And we looked at the handover documents where we had the earliest date of the 23rd of April 2019 to level 41 to 59. You may remember just about 5-10 minutes ago we looked at that.
Yeah.
So does this show that at some point these works were done and then resubmitted, because that's how Reem was able to do the cover and sealant work?
You mean that this has been done earlier than these dates and this is resubmitted?
No, as in after this date, between this date and the 23rd of April, or maybe even June, at some point after the 5th of March. I don't know what that was. Yeah, at some point after the 5th of March, the works were done, submitted, and assuming it was approved at some point.
I mean, that's an assumption. I cannot see it in this document.
Okay.
There is no way to confirm it through the document. But as an assumption, I would assume that, yes, the work has to be rectified at a certain point and then resubmitted and approved. But I cannot confirm it from this document.
Understood. Understood. Let's move on. We've got the closeout program.
Yeah.
Oh, this is a bit small. My lord, this is G2953.
Yes.
Here we've got levels 7 to 9, and the date of this closeout program is the 30th of April 2019. I'm just going to ask you to confirm this because I can see it, and if I'm wrong, then my learned friend will no doubt correct the position. But we've got Reem, for example, under curtain wall sliding door sealant, and to levels 7 to 9, it was due to do those works on the 7th of May and 8th of May 2019.
Yes, that's correct.
Okay. The significant part is probably here where we get to level 59.
Yeah.
We've got levels 6 and 59 on page G2955. And can you see under where it says EIFS, the big section here, where my mouse is, under that, it says curtain wall, sliding door sealant, Reem.
Yeah, I can see that.
Yeah, and the date for that, for those works, was the 8th of June, 2019.
Yes.
Now, what is the closeout program and what works does it relate to?
Now, closeout program, as you can see within the same description of the closeout program, this is to deal with the final touch-up work, with the final snags and desnags, and some minor silicone if it's missing around, like sealants or missing parts. And if you can assist me, please, Mr. Martin, to just zoom in on the description of this paragraph 17, because it's too small, I cannot read it. Yeah, thank you.
I can't go any further than that, I'm afraid.
That's fine. So you can see the gypsum partition wall and columns touch up. So when we say touch up, it means these are not the main works. These are the touch up work, which are to deal with the rectification or the snagging, desnagging. And then when we go to the MEP and the ELV, these are the low voltage. Also the final installation of the final fix of the electrical. Then you go to floor and wall, and then you go to the final coat of ceiling paint. Again, the ceilings, there might be some dust because these are outdoor areas in the balconies and the terrace. So this is to just finalize the final touch-up work and the final snagging and the paint. And based on this one, you can see also that whatever is related to Reem within the context of this schedule is to deal with the sealants, the final sealant that they put around the curtain walls.
Yeah, okay. And again, in the context of the delays, etc., where does this fit?
For delays, these are not the main works that they are balanced. These are the snags, which it's normally after then the main work has concluded. Then you start for snagging, desnagging, and scheduling who should paint first, who should put the scaffold there, who should remove it. So this schedule is to deal with this with the final touch up and the snags, desnags of the work, but not the main work and the delays that took place earlier than this one.
Okay. Now, the final section to deal with is just, which we've already touched upon, is the broken glass. Let me just stop sharing the screen, sorry.
Yes.
If I can figure that out. Yeah, it's to do with the broken glass, and we know that the variation order from our chronology. In fact, I'll take you through it, my lord. I'll tell you the court the numbers that I'm looking at just to assist you for your records. But the engineer's instruction 0098 is dated the 27th of June 2019 at E1722. And the variation order number 4 is dated the 30th of July 2019 at F1889. So, Mr. Kiki, you heard what I just read out as agreed, as agreed documents, if you like. Yeah. Now, the significance, of course, is disputed, but in the context of delay, again, just on that point, what's the relevance of the engineer's instruction 0098 and the variation number 4 in the context of delay?
Yeah. So if we look at the subcontract agreement clauses, which we have signed with with Reem. You can see that broken glass and some damages are expected in such a big project, and even this has been admitted in the witness statement of Mr. Al-Mahdi. So it is not unusual to have broken glasses and balustrades. Also, the subcontract calls Reem to do a special protection for this and to make sure that there is sufficient protection up to handover. So in another way, that Reem remains responsible for these delivered items until the handover. However, it is possible that other party might have damaged these glasses, which we accepted with Reem from the beginning at the site when we were discussing this one. And the engineer issued an instruction because this was an urgent thing. The broken glass balustrade is a safety matter for the building. So we cannot operate the building. We cannot open and receive guests in the hotel if you have a missing balustrade. So it might sound a small thing, a broken balustrade, but it's a major safety issue. And that's why, as per FIDIC and as per the contract, the engineer has issued the instruction immediately to rectify these works. By saying rectify these works, Reem, this doesn't mean you are responsible to pay for these because they are your responsibility to rectify them at your cost. That's not correct. The instruction is to deal with the urgency and the emergency of time to finish this scope as soon as possible because it has a delay impact on the project to be utilized and on the handover and on the utilization of the building. So the instruction took place. Unfortunately, Reem, they did not respect the instruction and they resisted, and they were very clear. They told me, if you do not issue, it means you or the engineer, do not issue a variation order that will confirm our right to be compensated for these glass, we will not proceed with the works. And this took the time between the engineer instruction until the variation order has been issued. Then after that, they started to rectify the work, and they placed the order, and they said it's a long lead item that. So they were fully aware that it will take time, but they did not consider how desperate we are to finish and to operate the building on time, because there are losses encountered. But they insisted and they resisted and they refused to comply with the instruction, and they asked for a variation order that has been issued at a later stage, which it's not the normal procedure of a construction site. And it's against the contract. The contract, whenever they have an instruction from the engineer, they should proceed and claim for compensation after that.
Thank you for that. There's still an echo, I don't know why. But anyway, okay. The final area I'm going to deal with is just the civil defense, devised civil defense certification. And at paragraph 61 of your witness statement, your second witness statement.
Yes.
You referred to the engineer's letter of the 15th of May, 2019, and delays to the civil defense certification. And you'll recall this morning that there was a discussion about the additional evidence, which I'm going to show on screen now.
Yes, please.
Now, this is the email from the 16th of March, 2019, from Emad Nassim, who is from the engineer's company. Is that right?
Yeah, he's the engineer, correct.
Okay, he's the engineer, fair enough.
Yeah.
And we've got numerous people who are copied into this email.
What's the reference to this email?
I don't know yet. I don't know if it's been uploaded from Malone and Friends instructing solicitor yet.
This is the one introduced this morning.
Yes. I'm sure Malone and Friend will give the reference once it's uploaded. Apologies if I don't have it yet, but yes. So this is the document from this morning. You are emailed, aren't you? Yes, and you're in the copy of this email.
That's correct.
And so are many other people from Five. And here the email is from the engineer to everyone who's involved in this email, saying, please find the attached PDF for the given comments by DCD, which is Dubai Civil Defense, after DCD inspection dated 14th of March.
Yes.
All parties on the charge to conclude all comments promptly as addressed. Please circulate this email for other parties that may, I think that's supposed to say, that may not be included in this email. Okay.
Okay.
Now, Salim Al-Mahdi is copied into this email, as is Mr. Nair. You can see that where my mouse is here.
I can see that.
Okay, like I'm trying to highlight it as best as I can. Okay.
Yeah.
So, and then we've got the PDF, which follows, which I'll rotate quickly. Oops, wrong way. Okay, so you've looked at this document since this morning, haven't you?
Yes, I did.
So you're familiar with what it is. Can you explain to us what this document is?
These are the comments generated by the civil defense further to their inspection to the site.
Okay, and is Reem at all mentioned in any of this?
They are not mentioned in this.
Okay, what's the significance of any of that?
Okay, now the civil defense inspection, and if I will have the chance to prove it with documents, which we have the documents, but I did not know that this will come. We have applied for civil defense to come and inspect earlier than this date, and this request has been dismissed and rejected by civil defense because the building was not ready yet. When I say it was not ready, it means there are absence of aluminium work, there are absence of balustrade, there are absence of minimum safety aspect for them to inspect. So the delay that the engineer was referring to in the letter that they sent to Reem, and on what I relied in my witness statement, talking about the direct impact of Reem in delaying the civil defense approvals, it's not to deal with these comments. Here there are two different things. There is the work of Reem has delayed, the delay of the works of Reem has delayed the inspection to take place of the civil defense, which is in front of us now, that took place after many rounds of failure due to the delay that took place earlier. However, when the inspection is happening, the civil defense, they do not deal with the inspection of the balustrades and the work of Reem. That's why, consequently, they did not mention these. So they are more focused on the fire alarm system, on the route of the escape, on the low voltage emergency aspect of the building. But for them to come to site, the building has to be completed, substantially completed, without missing parts of the aluminium balustrades and the windows. And the delay that we have referred to, I have referred to in my witness statement, and the engineer has referred to in his letter to Reem, was to deal with their delay that delayed the inspection to take place, not about the result of the inspection that we are seeing in front of us.
Okay. All right, thank you very much. I'm not going to ask you any further questions. So, my lord, those were the only questions in additional evidence in chief. I should say, I forgot to invite the court to hold the witness statements that I've identified with the witness as his evidence in chief. So, of course, I asked for that. Yes, but otherwise, I don't have anything further.
Very well. So it coincides with the timing in the timetable that we should break for lunch at this stage, which will take an hour. And so it's now 11:30 UK time, 2:30 Gulf time, and we'll resume in an hour's time. So it's, sorry, it's 11:30 now. We'll resume at 12:40 UK time, which is 15:40 UAE time.
So yeah, I'm trying to calculate.
All right.
Yes.
Yes.
Mr. Adiki, can you not talk to anyone about the case in the meantime, please?
Sure.
Yeah,
Sure,
and
Omar.
can I just use this opportunity just to say to Mr. Key, I'm not going to be calling him, so I hope he doesn't expect a phone call from me.
Yeah.
Oh, thank you.
I have. Thank you.
Thank you very
Thank you. Thank you. Thank you.
Good afternoon, Your Honor.
Are we all ready to resume?
Yes,
Is Mr. Akiki online?
Yes, Lord. Good afternoon.
Good afternoon, Mr. Akiki. You're now going to be cross-examined by Mr. Carvelis. Mr.
Thank you.
Carvelis, over to you.
Good afternoon, Mr. Akiki.
Good afternoon, Mr. Carvelis.
Can we make sure that you can hear me loud and clear?
Yes, I can hear you clearly.
Great. So do I. And if at any time you have any difficulty hearing me, please do let me know.
Thank you so much.
Thank you. So let's start with a little bit of background, if we can. I see in your second witness statement that you are a graduate of the INBA University in Beirut, right?
Yes, that's correct.
That's the Institut National des Beaux-Arts, the Faculty of Fine Arts and Architecture, right?
That's correct.
And then you had a master's in architecture, correct?
Yes, that's correct.
And then you worked for as a designer, as an architect for Ideal, I think. And then you moved to Dubai.
Yeah, correct. Sorry.
And then you to Dubai in 2007, and you moved to 5 in 2012, correct?
That's correct.
So you are an architect by education and a businessman and a manager by trade. Am I right?
That's correct.
All right. Thank you.
Thank you.
Now, you have stated in your witness statements, and I think you mentioned it again today. I think my colleague, Mr. Costel, asked you about your corporate role within 5 Real Estate Development, and you said that you are the Chief Executive Officer, the
Yes.
claimant, correct?
That's correct. Confirmed.
In fact, I see your second witness statement, the one in March this year, where you, in the very first paragraph, actually, paragraph 1, you say that I am the CEO and the authorized representative of the claimant, right?
Yes, that's correct.
You recall that?
Yes, I do.
Out of curiosity, why then you are not the person designated as manager of the claimant's trade license?
Because I'm the Chief Executive Officer, as simple as that. So my role is to execute, and I'm the Chief of the Execution Officer. And that's what is my position. This is my role.
Well, yeah, I asked this because usually the CEO of an entity in Dubai, it is also the nominated manager of that entity on the Ministry of Commerce, the equivalent of Ministry of Commerce entity. And this is not the case for you. It's a little bit odd.
Yeah, I mean, that's not the case, as simple as that.
No explanation. As I said, it's not really important. I think what is important is that you are the individual, the person that manages the business of the claimant on a day-to-day basis. Am I right?
Can you clarify exactly what is your question, please? Because it's clear to me that you are asking if I'm the CEO, which I'm confirming, but the other part, it's not clear. Can you please elaborate on this one?
Well, the Chief Executive Officer, if it is the Chief Executive Officer, manages the day-to-day business of a company, takes decisions.
Yeah.
Who is going to get paid, who is going to be hired, what projects will be pursued. Is this your role?
No, that's this is definitely my role whenever there is a project ongoing. Anything related to the project, from hiring staff or deciding on either engineering matters or commercial matters, this is my full role. Now, that's exactly my role. But what is the differentiation that you are trying to establish? It's not really clear to me. And if you want more answers, I mean, please ask more questions. But yes, I reconfirm that I am the one deciding on day-to-day anything related to the business, which is in particular related to the 5 Jumeirah Village project, that it's the subject of this case.
Fine. I'm not trying to make any differentiation. Don't try to understand what I'm getting at. I have my own line of questioning.
Yes.
Now that we established that, and since you are the authorized representative, that's your words. What you say or what you do are the words and actions of the claimant, right?
Yes, that's correct.
Okay. And presumably, since you are especially involved on a day-to-day basis, Your Honor, can you hear me clearly? Okay, thank you. And since you were on a day-to-day basis involved in projects that you say, I assume that you participated actively in the setting up of the strategy for this dispute, right? You talk to the lawyers, what will be your defense, your line of argumentation. You were part of this process. Am I right? You led this process, actually.
Yes, I did all my best to bring to the court the truth. That's
okay,
correct.
Thank you. Great. Now, you say in your second witness statement that you are a founding member of 5 Real Estate Development. I assume you mean you were one of the shareholders at the time of its incorporation. Am I correct?
No, I'm not a shareholder.
Were you at the time that it was incorporated?
Come again, please. Can you ask the same question?
When the company, when 5 Real Estate Development was set up?
Yes.
Were you one of the shareholders then?
No, I was not.
So you were not a founding member. What do you mean, founding member, in your witness statement?
Yes, Mr. Carlos, let me explain to you a little bit the background. 5 is a group of companies. 5 is a. It's not.
Don't go to 5 yet, just please, because I'm really trying to make sure that we will not spoil tomorrow's trip. So let's try and finish today. So please follow me. Were you or were you not a shareholder of previously Sky Developments, now 5 Real Estate Development, when it was established in 2012?
Yes, I will answer this question, but I will go one step back if you allow me. Regarding tomorrow's trip, I am available for the court anytime. If today's session will not be sufficient, I'm more than happy to participate, but except for tomorrow, because I have a commitment with the family, I cannot change it. But the day after tomorrow and the day after tomorrow, I'm fully available for the court, just between 2 brackets, to don't be misunderstood like how you said the morning, that this is a very important case and why I'm not available. I am available. So now back to your question, I was not a shareholder in this company, not at the inception and not after and not currently. So to just, yeah.
It is not perhaps that important, but that's what you say in your witness statement. In paragraph 4 of your second witness statement, your exact words that, or in 2012, in the capacity of the CEO and a founding member
Yes.
Sky Developments, which later became 5 Real Estate. So
Yes.
that's not accurate.
Sir, it is very accurate, but you are confusing two things. You are confusing a founder and a shareholder. You can found a company and make the foundation of a company without being a shareholder. I'm being very clear and transparent, and I'm reconfirming that I was not one of the shareholders of the company, but I was one of the founders of the company.
Presumably, you have also a law degree that, and that's why you make the distinction. But anyway, for whatever is worth, founder means shareholder and vice versa. Legally speaking, founder means shareholder. Member of a corporate entity means shareholder and vice versa. Let's move on.
Thank you.
So you said you are not a...
Well, it's just that I've got an audio issue. When my learned friend asked the question, it just has a slight echo. So I just wonder if he can reposition his microphone, if possible at all. I'm sorry for interrupting. I was waiting for a convenient moment, but I've got.
Does anyone else have this echo? Because every microphone in the room is off.
Okay. Yeah, it's a bit better now. Thank you. Maybe it was just a momentary glitch, but thank you very much.
Thank you.
Thank you. No worries. No worries. Now, you said that you are not a shareholder today. Fine. Who are the shareholders of the claimant? 5 Real Estate Development.
Yeah, there are 2 companies. They are mentioned in the trade license. I think it's 5 Investment and another company. We can check the trade license and you can see exactly who are the shareholders.
So the shareholders are 2 entities, 2 companies.
Yes, 2 companies, correct.
While checking the trade license so that we have the names at hand, is this the only corporate position that you have as within 5 Group?
It was not clear. I'm really sorry. Can you repeat, please?
You said we established that you are CEO of 5 Real Estate Development.
Yes.
Is this the only position that you have within 5 Group?
Yes, that's my position, but allow me to explain, if I may.
No, let me ask you the question and then you can explain. Are you also the CEO of 5 holdings?
No. Sorry to interrupt. I'm just wondering how this will assist your lordship in determining the issues in this case.
I have to assume.
Can I decide this?
I have to assume for the moment that Mr. Carvelis has a line of questioning that is relevant in his perception of the case. It hasn't been very long so far. If it goes on to an extent that everyone begins to think, where is this going, then I think it's legitimate to ask. But I think for the moment, we'll let it carry on.
So be it. Thank you very much.
So, do you have a LinkedIn account, Mr. Akiki?
What kind of account? Sorry.
A LinkedIn. Do you have a LinkedIn account? LinkedIn.
LinkedIn, yes. LinkedIn account, yes, I do.
You do?
I do.
Do you know what it says in your LinkedIn account? How you have described yourself? It says there that you are the CEO of 5 holdings.
Sorry, my lord. This is not evidenced in the bundle. In the trial bundle. Sorry. Wait. Sorry. Can I just make an objection here? My learned friend can ask questions. Fair enough. But he's asking questions on a LinkedIn account which I haven't seen. I don't think my witnesses at the moment has got it in front of him, and it's not in the bundle.
The witness can say yes, no, or I don't know. I don't see any difficulty with that. If he's put to a disadvantage because of details of a document he hasn't seen, that's a different matter. But I think for the moment, Mr. Carvelis.
Your Honor, I fail to see, by the way, the disadvantage. It is the witness's own account. It's not someone else's account. It's his own.
I've said you can answer the question. You can ask the question, and I'm sure the witness heard it and will answer it.
Okay. Are you a CEO of 5 holdings?
No, I am not the CEO of 5 holdings.
Who is the CEO of 5 holdings?
This is not a project. If you allow me to answer, I appreciate your way of asking question, but if you allow me for less than a half minute, you will have clarity more on all these questions. Just allow me to tell you what's the background. Okay, please. I understand you want specific answer to specific questions, but let me help you, assist you in getting to the truth. If you I am not the CEO of 5 holdings.
Are you a shareholder of 5 holdings?
No, I'm not a shareholder.
Is Mr. Mulchantri the CEO of 5 holdings?
Mr. Mulchantri, he is the chairman of the group.
Is he the major shareholder of the group?
He might be, as far as I know, yes.
Yes. Are you a shareholder? Do you have shares in the group?
No, I do not.
You do not. And 5 Group, is 5 Real Estate Development LLC part of the group?
It is part of the group, and it's an SPV.
Is 5 Hotel Management?
Is 5 an SPV for development of this project?
Is 5 Hotel Management LLC part of this group? Who are you waving to, Mr. Akiki?
Somebody was bringing me a tea. I said, no, please, I don't need a tea. So can you please...
5 Hotel Management LLC, is it part of the group?
5 Hotel Management LLC, yes.
Unlimited One, Limited, is it part of the group?
It's part of the group, but different shareholders, but yes.
So 5 Holdings owns the owner and every other company involved in the 5 JVC hotel project. This is what you just testified, right?
Yes, correct.
What is the business of 5 Holdings?
What is the business of? Can you please repeat?
Am I right to understand that 5 Holdings is a real estate developer?
No, 5 Holding is not a real estate developer.
What else is it?
It's a group of companies which they are involved in several parts of the business. One section of this is real estate development. There are other sections which are not related to real estate development, like hotels, hotel operations, and ownership of different assets. So it's not a real estate development company, to answer your question.
And when 5 Group develops a project, is it standard practice for the group that a company of the group owns the land, another company of the group develops, builds the hotel, the villas, whatever it is in Kuwait, and when there is a hotel involved, another company of the group operates the hotel? Is this standard procedure?
Yes, that's a corporate structure, which every entity of these has its own first independence and responsibility. But to answer your question, most of the project, yes, with the same structure.
And what is the turnover of 5 Group?
What is the?
The turnover.
I have no idea.
Turnover of 5 Group. Give a gross figure. 100 million dirhams, 1 billion dirhams, 10 billion dirhams. More or less. I don't know the number.
Yeah, I cannot comment on this. I'm sorry.
What do you do for?
I don't have it in mind.
What do you do for 5 Group? Not 5 Real Estate Development, for 5 Group. What do you do for 5 Group?
Any project related to real estate development, I'm the CEO of it.
Excellent. So you are, how much is the turnover of this department that does real estate projects?
No, I don't have it now present in my mind. I need to go back to my documents and then to check it.
Again, gross figure. I'm not looking for precise figure. 100 million, 500 million, 1 billion?
I really don't recall.
Would it be closer to 1 billion or to 100 million?
I really do not recall. I don't have it in mind. I prefer not to say, by respect to the court, something
But
that
you are the CEO.
Yes, I am.
And you don't know how much is the turnover.
No, I don't know.
What is the business? Let's go to the particular claim. 5 Real Estate Development LLC.
Yeah.
What is its business?
5 Real Estate Development LLC is the developer that was responsible to develop the 5 Jumeirah Village hotel project.
Did it have any other business before the Jumeirah Village Hotel?
No, it's an SPV. It's specifically established for this purpose.
Excellent. Can I please take you to... sorry, no, one question, because you said they are all independent entities. Does it have employees? 5 Real Estate Development.
Yes, it had when the project was ongoing. Now there is no business which is conducted by 5 Real Estate Development. So there is no employee currently employed by 5 Real Estate Development.
Because there is no project. Does it have a legal department? Does it have lawyers of its own? Does it pay for the lawyers? Does it have a chief of legal?
The legal department is sometimes like assigned to do services for specific companies, which one of them is 5 Real Estate Development, and consequently this will be counted and audited as part of the expenses of the company. Yes.
Assigned by whom? Who assigns them to?
By the group of the companies.
When you say group, you mean 5 group?
Yeah, I mean the companies that you mentioned. You mentioned many companies today in your discussion. So these are part of the group of the 5 group.
Okay, then let's move on. Thank you for this. That was the background. Can I please ask you can someone open E1, the bundle for Mr. Akiki?
I'll go to the job.
Do you see your screen, the document, Mr. Akiki?
Yes, I do see the screen.
This is a witness statement, which, if we go at the end,
yeah.
This is your own witness statement, right?
Yes, this is my signature.
Now, my friend earlier, when he asked you to confirm the witness statements that you have given in this case, he asked you to confirm the 2 witness statements that you gave this year in March and April. Understandably, because these 2, the 2022 witness statements were made under my colleague's care, this is an old one, when he was not even involved. He was not involved in this case. This is in October 2022. So is this your witness statement?
You mentioned October 2022?
October 2020, sorry.
Yes, this is my signature, correct.
And you see the statement of truth above it?
Yes, I do.
Okay, can we go to the top of this witness statement? Do you recall when you made this witness statement, Mr. Kiki? Open it again. Can you recall when you did this witness statement?
Yeah, I believe it's the date when I sign it.
Yes, why did you sign this? What was the occasion? What was the context? Why did you sign this witness statement? Why did they ask you to prepare a witness statement?
To witness in this case and to say whatever I know about this case.
Okay. This witness statement accompanied, was part of the documents that formed the claim form, the document which was submitted to DIFC court when 5 first commenced proceedings against Reem. And this was in October 2020. Do you remember this?
Yeah, I do.
Presumably, since we established earlier that you have the first and final saying in the management of the company and you were involved in this project, you knew that this was being prepared, this claim form, this action before the IFC court was being prepared, right?
Yes.
Yes, you did. Can you go at paragraph 11 of this witness statement? 11, please.
Mr. Calvelis, do we need to have the screen, have the witness statement screen up?
Your Honor, depends. If the witness has access to the witness statements, we don't need to have
Let's
it on
ask
screen.
Let me ask Mr. Akiki, do you have access yourself to the documents on the screen?
Yes, with the assistance of Kate. Can you give me the page, please, so I can put it on the screen?
E1, Sir Nabil.
No, which page? I have the bundle. I just need the page.
E1.
It starts at E, echo 1,
Yeah, but
and you need to, and we would like you to look at echo 6, E6.
yes, if you just give me 1 second, because the numbering system that I have, it doesn't call for E. Okay, just give me the number of the page, then I will go straight to that page. I'm really sorry for this, but just I'll do it.
Let's not lose time. I will bring it up. You will have a look at it, and I will close it again.
Yeah.
Can you look at the screen?
Page 202, Sir Nabil.
202. Yeah, just a second. I have the page 202. Yeah, so this is the witness statement, and which page of the witness statement you would like me to go to? Clause 11, paragraph 11.
Yes.
Paragraph 11. Yeah. Yes, I'm there. Thank you, Kate.
I wonder if the screen share can just be removed then so we can see the witness properly. Thank you very much.
Okay, we can remove it, yes. Okay, great. So you say in this paragraph, you state in this paragraph, I added the numbers in subparagraphs A, B, and C, and you state here that 4.5 plus 3.1 plus 64,000, that makes total 7,740,000, 7.7 million, more or less. And you state here that the claimant seeks payment from the defendant, 6 payment from C, from Reem, of a sum of 7.7 million, which is the same amount that the engineer found in his determination as owed by Reem to 5. Am I right?
Yes, that's correct.
And then you state at paragraph 23,
yes.
Despite the engineer's determination being issued on 5 March, I will read it for you, which confirmed the defendant's views, the defendant failed, refused, and or neglected to give effect and or to make payments to the claimant. This is what you state in paragraph 23.
Yes, that's correct.
Well, that assertion was completely and utterly false, wasn't it, Mr. Akiki?
Can you repeat the question, please?
I said, well, I just said that what you just stated in that witness statement was utterly false, was wrong, was a lie. Isn't it, Mr. Akiki?
No, definitely not.
Had you been paid the 7.74 million, Mr. Akiki?
Can I answer your question? Yeah.
No, you cannot. You can answer, but you can answer my question. Had you been paid 7.7 million by deductions made as a result of the engineer's termination, yes or no?
No.
You have not been paid. You have not. You did not make deductions.
The engineer made the deduction. However, Reem disputed this one, and that's why in front of the court.
Did you pay to Reem 4.5 million, which was the delayed damages deducted? How do you understand deduction? How do you understand deduction?
Can I answer?
You have not so far.
If I can answer, just give me time to answer, please, sir. Okay? So the determination is part of the contract procedure, and the determination calls both parties to respect the determination. However, if there is one party, which is Reem, which is mentioned here in my witness statement clearly, that they have neglected and rejected, and they did not accept the determination. So in the absence of the acceptance of Reem for the determination, these deductions proposed by the engineer will remain not valid until we put it in front of the court and to get certification from the court that deduction.
If you have, Mr. Akiki,
yeah,
when you commenced the proceedings to the court,
yes,
your lawyers did not ask that the court recognizes your right to deduct delayed damages. Your claim, and you are the CEO, you are the authorized representative, and you are the person that signed this witness statement.
yes.
You made a statement saying to the court that Reem must pay you. Must pay you 7.7 million. Not that you were right to deduct. Not that you were right to omit.
I'm really sorry. This is not the way you are putting it this way, sir. I understand, but finally, my witness statement is very clear. I'm referring to the engineer determination. I'm saying what the engineer has determined and what are the deductions, including the liquidated damages, and I'm asking the court to certify and to confirm this. That's what is written here. This was the intention. More than this, I'm not responsible for the things that you are trying to assert here. Please, sir.
Since you insist, I was prepared to let you go, but since you insist, look at paragraph 23.
Yes.
The defendant failed, refused, and/or neglected. Do you see this?
Yes. Neglected
to make payments to the claimant.
Yes.
To make payment. What payments did they fail to make?
Sorry, you are skipping one very important part and trying to
effect.
No, please. I mean, we are reading. We are all in front of the document. So what is saying the document? Neglected to give effect to the engineer determination. That's very important. This is the focal point here. That if can I say, if Reem they have accepted the determination, then it means they have already consent for the deduction and for the back charges that the engineer has decided. But in the absence of them accepting, and still they are challenging the engineer determination, so I'm asking the court here to give me right for this determination to ratify this right. That's exactly.
But Mr. Akiki, you did not stop there. This is the problem. You did not stop to give effect to the engineer's determination.
Yes.
You continue. What can you read? Can you read yourself your words again? Read them.
Yes, I can see it clearly. but also it's very
But
important.
what does it say? Can you repeat the words?
Yeah, can I
Read them.
explain what I'm saying? Because this is, it's my statement.
Read them, Mr. Akiki, read them. Read them.
Yes. So the defendant
Read them.
failed, refused, and or neglected, okay, to give effect to the engineer determination and or to make payment to the claimant. So here we are. Can I explain what I'm saying, sir?
No, you cannot. No, you cannot. No, you cannot. You answered my questions.
Mr. Calvetis, you must allow the witness to finish his answer.
Yes, but if his answers are relevant to my question, Your Honor, and they are not,
I think
he's trying to escape.
Mr. Calvetis, I've given you quite a lot of license at the moment, but I think the witness must be allowed to make the point he wants to make. Mr. Aliki.
Thank you, Lord. I really need it because I think I have the right to explain my intention of what I'm writing. So what I'm writing is very clear and it should not be twisted around. An account between two parties. If we agree both of us on an account, then there is no problem. The problem is resolved. But if we both, one party agrees on the determination and one party do not agree, it means for me, it is not granted to me that this is my right to hold this payment and this amount that they owe me. So they owe me this amount, 7.7 million. So what I'm writing here is very clear. I'm not trying to say that there is a money that they should have paid me and they did not pay me. I'm saying that the engineer determination was not accepted by Reem. It was refused or neglected. And therefore, this amount I'm asking from the court to give me the right to hold this amount, which is 7.7 million. As simple as that.
Are you done?
Yes.
Right. Mr.
What
Calvetis,
happened
your
with
turn.
this claim? Sorry,
Thank you.
excuse me, Your Honor.
You go ahead, Mr. Calvetis.
Excuse me, Your Honor.
You go ahead. Back to you.
Thank you. Thank you very much. What happened with this claim, by the way, Mr. Akiki?
Which claim?
This particular one, for which we gave the witness statement. What happened? Do you know?
Yes, the court decided that we pay 1.8, if I'm not mistaken, to Reem.
So the court decided that you were 10 million wrong in your
Sorry?
witness statement.
Sorry?
I will move on. I will move on. You know, I appreciate that the first claim was brought by the claimant was resolved when it was dismissed back in May 21. And it is not anymore related to this claim that we have. But I had to do it to raise it today because you are the only the sole factual witness for him, for 5, and your very first testimony in this case hasn't been very reliable. Let's move on. Let's go to our case now. Let's start looking at the facts of what was occurring on site for the period starting 15 March 2019 until the hotel had its grand opening on 2nd September 2019, right? That's the final stage of the works. I think we can agree on that. Before we go into the details, I would like to ensure that we are all clear on how Reem's scope was to be carried out. So, in your third witness statement, you confirm that you had read Mr. Lahmahdi's witness statement dated 24th March, the first witness statement of Mr. Salim, and that you generally agreed with paragraphs 15 to 23 of Mr. Salim's witness statement. Although I accept that you did make clarifications to that statement, and I will read those shortly. Is this all familiar to you?
Yeah, I mean, let me see and let me read, please, and then I will tell you.
Which paragraph is it?
It's paragraph 10 of the reply witness statement. And just to assist Mr. Akiki, that's the witness statement from April 2022. Just to assist my learned friend.
399?
Thanks, thank you. Yes, if you go at paragraph 10 of your third witness statement, Your Honor, it's in paragraph E.
I have it.
Okay, thank you. So at paragraph 10 of your witness statement, Mr. Akiki, you say that you agree.
I just need 1 second to put it on the screen. Just give me 1 second, please. What's the page number, please, Kate? 17?
172.
No, give me the page only. I don't have other than pages only. Can get me the hard copy if you don't. Let's have the hard copy, is easier. Am I allowed to see the hard copy?
I've got no objection. Do you have any objection?
The way we're proceeding, Your Honor, if it helps, if we move on, he can look at whatever he needs to look.
Yes. If you look at the hard copy, yeah.
Thank you. Which page of the witness statement?
Paragraph 10.
Paragraph 10. Yes. Yes, I have.
Yes. So you say, as to paragraphs 15 to 23, this is Salim's witness statement.
Yes.
I agree that the steps out were the agreed procedure for completion of the defendant's work. And you made certain clarifications, which I'm fine with. I'm just at the first part, the first sentence. That's what you say here. You see that, right?
Yes.
But paragraph 15 to 23 of Mr. Salim's witness statement describes the process. This is especially in paragraph 17 of his witness statement.
Can we have
To summarize,
Yes.
once Reem was provided with access to a portion of the size, the procedure was essentially Reem performs work, then the main contractor performs works.
Which page? Sorry, which paragraph of Salim's witness statement?
17.
17.
Page 4, the whole of page 4. You agree to this? Mr. Akiki, you have said in your witness statement that you agree with this. I summarize it. I just summarize it. You already said that you agree. So let me summarize and follow me, please.
Yes.
I think we can agree that the procedure was essentially Reem performs works, then the main contractor performs works,
Yeah.
then Reem again performs works, then the tiling contractor, then Reem again, then the eaves contractor and the tiling contractor, and Reem finishes. Is this sort of correct, my description? Is my description correct?
Yeah. Yes. Yes.
And Mr. Salim, he noted that between each stage of those works, the engineer would be involved to approve one contractor's work and hand over of the site to the other contractor. Do we agree so far?
Yes.
I think we can agree. It's not.
We do agree.
Reem finishes, engineer confirms, provides hands handover of site to the main contractor, he finishes, then again to Reem, and so on and so forth. I think we can agree on that. That's the process.
Yes.
Yes. At paragraph 10 of your third witness statement,
Third witness statement.
your third witness statement, number 3.
You should have it already.
Ah, this is the same one. Okay, I have it.
Yes.
Yes. Okay. Which paragraph?
You say, paragraph 10, the
10.
one
Yes.
we were discussing. You say that as to paragraphs 15, 20, 23, I agree that the steps set out were the agreed procedure for completion of the defendant's work, and then you go on to make certain clarifications. To clarify and reiterate, I accept that the defendant's work were dependent upon completion of concrete, aids, and tiling work. You see this, right?
Yes.
But I have not held any delays by those contractors against the defendant. That's what you're saying.
Yeah.
The
correct.
delay analysis, your delay analysis, we will discuss it later on, shows that the delay calculation is 170 days after completion of the each works. That's what you're saying.
Yes, that's correct. Correct.
Okay. Let's see page 1094, E1094 of the bundle. Now, this is your delay analysis that you prepared and referred to in paragraph 10. Am I right?
Yes. You're right.
Is this, can I please ask you out of curiosity, is this your first delay analysis? Or have you done a delay analysis before?
Yeah, it's not my first delay analysis.
You have done before for a trial or for a project?
No, I mean for previous projects. I did.
For?
Yes, I did other delay analysis. That's correct.
For a trial or for a project? Did you present it to a trial before, or this is the first one that goes to trial?
No, not to the trial. It was just for project purpose.
All right, and you prepared it yourself?
Sorry, and what?
You did it yourself?
Yes, I did it myself.
You were the one that took all those lines and you did it. You used Primavera yourself?
I don't use Primavera, but I have engineers and planners who operate Primavera. Yeah, go ahead. Sorry.
So it was your planners or you that prepared this delay analysis?
I did this one myself. It's an Excel sheet. I did it myself, but the information I collected it from my planners.
Okay, so when you did the delay analysis, did you take into consideration, for example, even relied upon the Society of Construction Law Delay and Disruption Protocol or some other similar publication?
I relied on all the facts that I have from the project and from the project records and from the project.
That's not my question. This will be my follow-up question. For now, my question is very specific.
Yes.
Did you rely upon the Society of Construction Law Delay and Disruption Protocol or some other protocol by other similar organizations?
No, I did not.
The American one, for example?
No.
Why is that? You thought that it was irrelevant, that it was inapplicable? Why?
Okay. The purpose and why I did this analysis is very simple. I have seen that in the witness statement of Mr. Al-Mahdi, he mentioned that his work were dependent mainly on 3 activities, which the first one, it was the concrete work, which I fully agree with this. The second one is the tiling. I partially agree on this because not everywhere their work, they were dependent on the tiling work. And the third one is the eaves, which also I partially agree on this, because the eaves, some places they were related, some places they are not related. So based on Salim's statement that his work, they are dependent on these three activities, which I accepted, even there are partial places, yes and no. So I took these activities to see, and I got the information from the project documentation when these activities, they have been completed factually on site. And from these dates, I checked the agreed schedule when Reem, after these dates, they were supposed to finish their work. And the latest activity was 12 days after the eaves work. And based on this one, I give the 12 days, and then I assess where the work was supposed to complete, which is, it was in October, November 2019. However, I stopped the delay at the 2nd of September because I consider that this is the day when the operator started the operation of the hotel. And I consider it personally, it's not fair to keep counting the delay for Reem beyond that date, because we took the responsibility, we operated the hotel, we allowed the operator to come in. So it doesn't make sense to keep counting the delay of Reem. This is how I put it in this schedule that you have shown. So I did not rely on any international norms of calculation. I relied on the contract documents and on the facts on site when these three activities they finished, and when Reem were supposed to finish as per the schedule, and when factually they did not finish, but the hotel opened, which is 2nd of September 2019.
Are you done?
Yes.
Okay, let's go back to my question. Thank you for this. We will visit all of that later on, but let's go back to my question. Did you rely on the Society of Construction Law Delay and Analysis Protocol, yes or no?
I already answered no.
No. When you perform the delay analysis, what method do you use? Can I help you? Did you use impacted as planned, time impact, time slice, as planned versus as built, retrospective, collapsed as built analysis? Which of the one did you use? Did you apply?
None of these. I used the one that I just described.
None of this. The only reason that I'm asking,
yes,
Mr. Akiki, is I'm trying to decide if I will treat you as an expert who prepared that made a proper scientific exercise aiming to identify the critical path of the various project activities and the causes of delay. What I just described is the description, is the definition of delay analysis, or if it is just your assessment of delays based on your understanding how the works were carried out. Let me finish. Let me continue. Carry on this. Can you confirm that you prepared whatever you call this document after considering all evidence available? Can you confirm this? It's a yes or no. It's very simple.
Yes.
All of it. So your document here, whatever you call it, it reflects the reality, what actually happened on site.
Yes.
Is this your testimony? Thank you. Let's go now again to your delay analysis. And let's see now this page.
Which page?
1295.
1295.
Yes. You see there is a very big red arrow at the bottom. You see it, right?
Just
How can it be missed?
Yes. Yes, I can see.
Reem delay once 170 days. These are the 170 days that when you are referring in paragraph 2 of your witness statement, right?
That's correct.
And in paragraph 10 of this famous witness statement, the third witness statement, this famous paragraph 10, you make a specific point that you do not hold Reem liable for any delays other than the last 170 days. This is what you repeated when you had this long, after I asked you about the Society of Construction Law Protocol, and you made this long speech, not on the question that I asked. This is what you said. You said, you repeated that the only delays for which Reem is culpable, is responsible, are these 170 days. Will you confirm it again?
Yes, I do confirm the way how
Excellent.
delay.
Let's move now to paragraph 22 of your witness statement.
Yeah.
Let's go now. Let's see what you say in paragraph 22. It's page 1789, French Revolution.
Okay, sorry, I did not understand. So paragraph 22
of your third witness statement.
Yes.
Okay.
Yeah, I have it.
Okay. So let's see what you say here. It's at the very top. I appreciate and accept that the defendant sent its many delay notifications. You respond to Salim saying that, hang on, we sent many delay notifications. We made many delay notices. And you respond to that by saying, I appreciate and accept that the defendant sent its many delay notifications. The defendant was not held accountable for any delay that may have been caused by other subcontractors, and the delay analysis provided of 170 delays is purely the defendant delays, covering only their own activities and execution of their own contracted works, as the calculation of the defendant's delays starts from after the completion of concrete, eaves, and tiling works. Therefore, the delay notifications are of no assistance. Do you recall this? Do you remember?
Yeah,
you
I
said
remember.
this.
I said,
okay.
correct.
So, how I understand it, you admit here that Reem filed over 200 delay notices, and these are, in order to say that are of no assistance, you obviously looked at them. You told us just now that in your preparation of your delay analysis, quote unquote, you looked at everything. As a delay analyst would do actually, or should do. So you looked at them and you saw that Reem filed over 200 delay notices relating to matters concerning civil works clearances, eaves clearances, waterproofing clearances, cradle access, loading platform access, tiling clearances, scaffolding, submittal reviews, right? You did. You considered all that, correct?
Yes, I did.
You did. And then you go on to say, in this respect, I also state with regards to Mr. Al-Mahdi's Salim's paragraph 49 to 51, that the delay analysis submitted does not account for the delays which occurred due and any delay caused by the eaves contractor, right? The delay analysis is very specific and clear to the fact that the 170 days is purely accountable towards the defendant's delays after the eaves contractor finished its scope of work. So again, so that we are perfectly clear, you specifically dismiss the importance of the delay notices issued by Reem because up to 15 March 19, you acknowledge that Reem was delayed by others and you accounted for the delay of the others in your delay analysis. Is this correct? Is my understanding correct?
You're understanding correctly.
Excellent. So, I apologize, I need to be perfectly clear on that. I don't want to leave any room of misinterpretation. At paragraph 49 of his witness statement, Salim notes that the H contractor was appointed in January 2018, which was substantially later than originally set out in the program. At paragraph 50 of his witness statement, all those are paragraphs that have to do with what we just discussed. He notes that 5 did not install the cradles until January 2018, which he stated, by the way, was much later than what had originally been recorded in the program. And at paragraph 51, he states that these two factors severely disrupted Reem's work. You admit, as we say in paragraph 22, that these points are true, but in your opinion, they are not relevant because your delay analysis took all of that into account. Is that correct?
Yeah, that's correct.
Okay, excellent. Let's see now a document which will not be new to you. Let's go to F508, the bundle. My colleague tried to preempt. He saw it coming and tried to preempt it with his earlier questions. 506. 506. 506, whatever it is. You took your time earlier this morning to explain what this document is, you remember, right?
So,
Yeah.
Mr. Cavadas, what page is this?
F506.
F506.
505. I think it starts at F505.
Right.
There are a number of, how you call them, handover. Sorry.
Right.
Working space handover.
Yeah, working space handovers, right? Do you see it? Do you see it, Mr. Kiki?
Yes, I see.
Okay. Let's take this one. The one which is on screen, F505. What level is this? Can you tell us? 41 to 58, correct? It's at the top of the document.
41 to 58, yeah. So what is your question, please? Can you ask your question?
So this is for levels 41 to 58, right?
This is level 41 to 58, yes.
Yes. And this is a working space handover.
That's correct.
This is the document that 5 issued. You agreed with my colleague earlier this morning.
Yeah.
To give access to Reem to install the external balustrade cover and sealant. Am I correct?
Yes, that's correct.
And this date was issued on 18th May.
Yes.
Right? After 15 March, in other words.
Yes, that's correct.
So the first time that 5 made available this particular section in, I can't tell, grids T1 to T2, levels 41 to 58, whatever this means, I'm sure you understand better than me. It was in May, correct? That's when Reem had the opportunity to go and work. And this is after the H contractor finished, correct?
After the EAPS contractor finish, yes.
Okay, and if I walk you all those handover protocols, whatever you call them, notices, all those documents. We will see that this goes on until June. My colleague earlier in the morning showed the last one, right?
Yeah.
So Reem received access. So, and you say that by beginning of, by 3rd of March, I think, each contractor had finished everything, correct? Everything was done.
Yes.
Each contractor done. Nothing, nothing to do. Do we agree?
I will
agree.
When you finish, Mr. Carvelis,
I will. My question.
I cannot just listen to you and say yes or no. That's not the way how this is a very delicate matter. This is a very delicate matter. The court needs to know, and I have the right to explain it in a very calm manner. If I want to be pressurized to say yes or no, I cannot continue this way. I'm sorry. I will not give the truth to the court. You cannot just squeeze me to say yes or no. I have the right to say and explain what is there, what is this document, how the work has been done. Otherwise, why am I a witness? To say yes or no? It's very.
I'm sure whoever explained, told you to say that, he didn't. It doesn't. I don't think he explained the whole story. It's not up to you whether you will answer or not.
Mr. Carvelis, a witness must be entitled to explain his answer. So
once he gives an answer,
ask your question, then give the witness the opportunity of answering it. Sometimes it helps if you start with yes or no, but then again give your explanation. But
okay,
Mr. Carvelis, ask your question again.
We went earlier. We did this painful exercise earlier, and we established that you took into consideration any delays that happened before 15th of March, everything that happened before 15th of March. You took into account everything. And then you have stated, and you repeated again to my colleague just earlier, a couple of hours ago, that 3rd of March, the AIS contractor was finished on everything.
Yes.
Did we or did we not?
Yes, we did. Correct.
Yes, we did.
Yes.
And we now have documents.
Yes.
We agreed also a few minutes ago that the process is AIS contractor finishes, a ring follows. Correct?
Correct?
Yes?
Yes.
We also established, you have said many times, that from the moment the AIS contractor finishes, a ring must finish within 12 days. Yes?
Yes. Correct.
Yes. Excellent. And we have now evidence that shows that you say that the AIS contractor finished on 3rd March. I don't agree, by the way, but it doesn't matter. What's important is what you say.
Yeah.
The contractor finished much later. But let's take on face value what you say, that he finished on 3rd of March and 5 gave access to Reem for this particular sector 2 months later. That's what the document. So
sorry, here I need to explain. So here I need to explain. Okay. There is no doubt that the Eve's contractor has finished by the date, which is 3rd of March. It's already certified. I refer to a document extracted from the engineer inspection on site. So there is no further doubt beyond this, unless there is other document to prove otherwise. Now, the access given after 2 months, it is correct. But what is not correct, that it is because of some delay caused by the Eve's work. This is an important point that we need to understand, and I need to explain it so it will be clear to everyone. This document that you have shown on the screen is to deal with the cover of the sealant of the balustrade. Before then we reach to this level of work, there are many phases that Reem they have to deliver before then we reach here. And this is not related to the eaves. And that's why the morning when we were discussing and Mr. Martin was asking me, and then I tried to correct his statement by saying, in some cases, the aluminum and the glazing is dependent on the eaves, but in some cases, no, which this is the case. This is particularly the cover of this one is not related to the eaves. And when we give the access for the is because they have installed already their balustrade and they finished their main work installation, then we give them the access. So by me giving them the access in that date does not mean because of the delay of the eaves. This is all what I wanted to
let's break. Thank you for this. Let's take it now word by word what you just said.
Yes.
You say that 3rd of March, eaves contractor had finished, right?
Yes. Yes.
And we agreed earlier that the sequence is eaves contractor, glazing contractor, right? Sealant and then glass. Common sense.
No.
Sealant. It's the opposite.
It's the other way around. Glass.
Exactly.
You don't put the sealant in the air. You put it on the glass. So the glass has to be.
On the glass,
yes.
which is the next. I agree.
Yes.
I'm with you.
Thank you.
That's exactly what I was looking for. So we have 8% of March. They finish the work. Then Reem must do their work.
Yes.
They have to, Reem gets access 2 months after. Right? It's not disputed. It's May. They got access in May.
Yes.
Correct? And this delay is the result of other work that Reem must do.
Yes. So
yes, and hang on, let me understand.
Okay.
And they did not do it, and they were late, right?
Correct.
And I'm sure you sent them 25 notifications for this period, from 3rd of March to May, 18th of May, ACE was finished, Reem was not ready. I'm sure you sent them plenty of delay of notices. Did you not? You were in a hurry to finish. Your owner told you they want the hotel end of March.
Yes.
We are in that period. You insist that AIDS were finished in March, early March. We are 2.5 years after. You cannot hand over, cannot hand over this particular section to Reem because Reem is responsible. I'm sure you have a pile of notices, a pile of emails and letters sent.
There are notices which have been addressed
there are. Can you show me one? Show me one. Show me, I dare you, show me one in the whole bundle, one notice.
Yeah, I don't have it in front of me now, but we were in, actually we had weekly meetings also to record the delays of Reem, and there are notices and there are weekly meetings addressing the delay specifically of Reem, and I can provide you with all the documents starting from notifications to the weekly meetings, and then you will see that yes, we were under that pressure and Reem has delayed. Yes.
Mr. Akiki, the time for that was last January.
The time
last February. The time for this was last February. I put to you, and I strongly recommend you take my word for it to save your time. There is nothing in a few thousand of pages in the bundle that shows anything that resembles a notice, an annoyance, minutes of meeting, anything by 5 for this period. Nothing at all.
Yeah.
in thousands of pages. Let me move on. We cannot stay on this forever.
I think the
As
witness
much
should
as-
be able to, he has the final word. We can't just have comments and then no, it's question answer.
Mr. Carvelis,
Is my que-
allow the witness to answer that. Do you want to answer, Mr. Akiki?
Thank you, Your Honor. I disagree with you. There are notifications, there are persistent delay by Reem from the beginning of the project till the end. And we are not sitting and writing every day one letter, but there are letters consistently addressed by the engineer and 5 to Reem. There are documents documented in the weekly meeting and showing graphs of the delays of Reem. That's my answer. And please, now we can carry on.
Since your answer, you had the opportunity again. Let's talk now about the document that we brought this morning. And my friend again tried to preempt this famous Atkins document. It is now on record, Your Honor. What's the number? What's the page number? If you can bear with me, I will give you the page number quickly. Soon. In the meantime, if we can bring it up on screen, this is the email. To remind you, this is the email from Ahmad Nassim. He's the engineer, right? He was the engineer.
Yes, that's
The
correct.
one acting as engineer for Atkins, right?
Yes.
Amongst other you, Salim, many.
Yeah.
Right? It's this document. And this document is the DCD inspection, given it's for the given comments. I read out the email, Your Honor, if you can go to the email first. Please find attached the PDF file. Yes. For the given comments by the Dubai Civil Defense, that's what DCD stands for, right? After DCD inspection, dated 14th of March, correct? Correct? It's M65 by the way, Your Honor.
Thank you.
On bundle.
Thank you very much.
Let's see now the table, please. Can we switch back to the table? Yes, this one. Oops. The other way. One more. Excellent. Can you see it, Mr. Agigi?
Yes, we can see.
And you say here that I think you agreed with my colleague earlier that we see many of the subcontractors, the MEP and the ELV one repeatedly, by the way, the low voltage and the MEP repeatedly. I don't think they were that. Doesn't seem that they were up to speed. But I think you agreed with my colleague earlier that there is no reference to Reem in this document.
Yeah, there is no reference. That's correct.
And you said, and you carried on to say that, yeah, and there is no reference because they don't care about external facade, and the DCD is not interested about facade. They're only interested about issues which are relevant to the security and safety of the building. Is this what you said earlier?
Here I need your patient to explain this part. As I said, the morning civil defense, they have a necessary condition to come to site, which is the substantial completion of the building, including the facades elements, the balustrade, the glazing. So this is a necessary condition for them to come and inspect. But once they inspect, once they accept to inspect, they do not go and check the aluminum work. This is exactly what I said. They care more about the safety aspect of the building.
Can you go to second page of this table? Can we scroll down there, the second page? Can you go up from the bottom? 1, 2, 3, 4, 5, 6, 7. What does it say? Read it for me loud, please.
You are asking me to do that?
Yes, yes. What does it say?
Sure. 1, 2, 3, 4, 5, 6, 7.
Highlighted one.
External facade works to be completed. Yes.
Yeah.
Civil.
And who is responsible for this?
Civil. This is, I really do not recall what was exactly missing there. If it's aluminum or balustrade, eaves, maybe some parts they were not completed yet.
I totally agree. It's 5 not 3. Let's go now, because you said it earlier to my colleague earlier.
Yes.
Let's look at because you made a point. Let me find it, please.
What are you looking
Yeah, I will give you a moment, Your Honor, if you can bear with me. Where is it? The letter mentioned in paragraph 61. Yes, this one. Can we project it on screen, please? And what is the number?
E1092.
Hmm?
E1092.
E1092.
Right, thank you.
I want to be fair with you, Mr. Agigi, as much as I can. So, why did I brought this up? Because in paragraph 61 of your second witness statement,
Yes.
the one you made rushing without first seeing Mr. Salim's witness statement, you say in paragraph 61, you mentioned here this engineer's letter of May 2019. This is your defense, effectively. This is a letter dated 15th May 2019.
Yeah.
The one we discussed before, to remind you, is the day after. It's 16. Sorry, that was in March what we discussed, and this is in May 2019.
Yeah.
2 months after, in which document, and this is one of the 2 pieces of evidence.
Okay.
One of the 2 pieces of evidence in the entire bundle that have any third-party reference to Reem's delays, and we will talk about the other one soon, where Atkins, basically, they're saying that there is a severe delay in the execution of works according to the contract between Reem and 5. And second paragraph, this directed to delay in achieving the Dubai Civil Defense certification. Now, we just established that 2 months before, on 14th of March, when there were comments for inspection by TCD, it was not mentioned, right? And I ask you, what is the basis on which Atkins said that there were serious concerns and there were severe delays? What was the basis?
Yeah.
Where is the evidence for this?
Yes.
Where is Atkins? To be precise, where is Atkins?
Sorry, I'm confused. What is your question, please? Can you repeat clearly?
Where is Atkins? Why Atkins is not here today to explain
Because
how come
Hmm.
you want to answer one by one? Do you want all questions together? As you want.
As you wish. You feel comfortable, please.
Let's hear from you. What about Atkins? Why are they not here?
Why they are not here? Well, I believe we have a clear determination from them. We have clear letters that you can see. You have said the morning or maybe a few hours ago that Atkins is an international and professional and respectful engineer. So therefore, we have all the evidence from them. We have all their opinion in writing, already documented. And there is no further things to be said from them. This is how we see it. However, we had the chance together with Reem to debate and to agree or disagree on their opinion during the determination. And therefore, we did not come to an agreement because we have accepted the determination of the engineer. Reem, they have rejected it. So that's why I did not see benefit from them to be witness in this case, because their documents are self-explanatory. And if we need anything, we can go back to them. So that's why they are not here. In this.
So their documents, your answer to my question is your documents are self-explanatory. This is what you said.
Their documents are self-explanatory.
Their documents are self-explanatory.
Yes.
Explain me, show me in this particular document
Yes.
that I showed you now.
Yes.
This self-explanatory. Show me one particular one.
I will explain to you because the date of this one is 15th of May, and you are referring to the inspection of Dubai Civil Defense, which was the 13th of March, if I'm not mistaken. So what Atkins here, they are saying is a translation of their witness for not only for this period of time, but for the whole process and the delay that has been persisting by Reem from the beginning of the project. So here what they are saying, literally, I would like to repeat exactly what Reem is saying. MS Reem has several times committed to daily, weekly progress meetings for the completion of their scope of work on time as agreed. However, never achieved so far. So a consultant with the caliber of Atkins writing this, it's not a result of 1 week delay or 2 weeks or 1 month. This is the pattern that has been established from the beginning. However, let me please continue. However, never achieved so far. This directed to delay in achieving MS Dubai Civil Defense certification and all other interlined inspections such as EHS, which is Tarakhis and Nakhil and so on. So here again, I want to explain what Atkins, they are clear. Sorry, I did not finish my answer. Sorry, please. I need
and you will have the opportunity.
You cannot cut me like this. Yes. With due respect, I need to finish my answer, please. Okay. I never interrupted you. You took a lot of time and you want from me yes or no only. This time I need to explain myself. Please let me finish my answer if you allow me.
Okay, no, you will first answer my question, then you can say whatever you want. Again, what you are saying is that this paragraph here, the second paragraph of this letter from Atkins is evidence of Reem's delays. This is your testimony today. This paragraph is evidence of Reem's delays. Is my question clear?
Your question is clear, but I would like to finish my answer if you allow me.
Answer my question, and then you can say whatever you want.
But that's not how things can work. I mean, I was answering, and you interrupted me in the middle of my answer, and you want me to just pick and choose what you want to listen. I'm really sorry for that. I need to finish my answer. It doesn't work this way.
I think, Mr. Carvelis, if we allow Mr. Akiki to finish his answer.
Thank you.
And then we will go back and then we will have a few questions after he answers.
Yeah, you
yes,
can. I mean, nobody is delaying you or interrupting you when you ask questions. So I'm sorry, I need to finish my answer. That's all what I'm asking.
Mr. Akiki, go ahead, please.
Thank you, sir. So for Reem to say, for Atkins to say that Reem, they have delayed the civil defense inspection. Here where it is important for you to know, Mr. Carvelis, that without the presence of the elevations on site, and I can prove this, I did not submit it to the court because I did not think this is of relevance, but now I can submit how many times the engineer has tried to apply for the inspection of the Dubai Civil Defense, and they failed. They came to the site. I was there the morning, 7:30 the morning they come. I was there with them. They look at the facade and they see it is not ready, and they say, sorry, it is dismissed. So the inspection, it is dismissed 2 or 3 times, and I am willing, if the court will allow me, if Your Honor, you allow me to submit these evidence that they came several times and they were not willing to even visit the site because of the facade. Okay, so this is exactly the meaning of the sentence that Atkins is saying. Atkins, they are not saying you did not comply with the comments of civil defense. That's not what they said, and that's why you took me to that document to show me that there is no relevance of Reem comments in the civil defense comments. As I said, the facade is a necessary condition for civil defense to come and inspect, but whenever they come and inspect, they don't look anymore into the aluminium. So that's my answer for that part. Thank you.
Are you done? Are you done?
I just said this is my answer. I just said this is my answer for this part. It means I am done. It means I am done.
Excellent. Let's go back now to my question. Let's go back to that document.
Yes.
What you say is that this particular second paragraph is evidence of Reem's delays. Yes or no?
Yes.
And you say this because Atkins is international and respectable. And if Atkins says so, it must be so. Yes or no?
No, because I want to continue why I'm saying this, and allow me to say. Not because they are international only and because they are a reputable company, but because they were witnessing the site like me on daily basis. And that's why I rely on their statement.
Okay. And then you argue that they really meant what they really meant, because all those that we described, how did you call it about the facade? Did you call it? The elevations, what did you say? The elevations were not right, and they told them to change the elevations, and the civil defense would come at 7:30 in the morning and would not put the tick. All this was meant in this paragraph, right? The only document relevant to civil defense is the one that we looked earlier, which does not mention Reem at all. Yes?
I really did not understand your question. Can you please repeat it?
So, again, from the top. So you are saying that what Atkins really meant in this paragraph, which we don't read it in the words that you used, what they really meant, Atkins, was that Reem was responsible for delays of the civil defense inspections, approvals. That's what they really meant. And they really meant that this had to do with the instructions about elevations and whatnot they gave to Reem, which Reem ignored. The only document that has to do with the civil defense inspections is the one that we discussed before, which mentions nothing about Reem. We agreed on that. Yes? We agreed that it does not mention.
Sorry, I mentioned to you that if the court will allow me to produce more documents related to civil defense and stating that they are not accepting to visit the building because the facade, which you are searching for the word, it is the facade, not completed, then yes, I will provide you with more documents to prove what I'm saying.
And then I cannot help but ask. You have a claim. You have lost every court case in this project until today. You have a claim against you, which is 15, 17 million dirhams. You have a theoretical counterclaim of I will not double count, I will leave the 7 of the engineer out. Okay, I will not ask for payment. I will just count your indemnity claim and your loss from 18 claim. You have a 20 million plus claim, and you only now realized that your argument that Reem was late is not supported by documents, and you want permission to bring those documents now. And you are the CEO and in charge of the strategy for this case, right? Let's go on.
Mr. Can I
Let's go on. That was not a question, so let's not go on.
Mr. Calvert, if it wasn't a question, you shouldn't have made it. It's not an opportunity to say. So I'll let the witness answer it.
Exactly.
Your Honor, there is a limit, it's common sense at some point.
Yeah, exactly. There is a limit for everything, sir. So that's why I am allowed to answer. If I be, yeah. So, thank you, Your Honor. So this document about civil defense, if I'm not mistaken, this has been brought today morning. Am I right, Mr. Martin?
I don't think you can ask questions of
I cannot. Okay, but I believe that this document has been brought to this court today, the morning. I did not have any chance to even answer. So this is my only chance. And what I'm saying that this is not the first inspection of the civil defense. We went through several civil defense inspections, which they have been dismissed because of the work of Reem, which is balanced on the facades. And I'm saying very simply, allow me to produce these documents, and I know what I'm saying, and I'm confident about this, as simple as that.
Okay. Well, we'll listen in due course if any application is made, but for the moment, Mr. Carvelis will carry on with his cross-examination.
Thank you.
Let's go back to your delay analysis. No. Paragraph 62 of your second witness statement. You are saying that you have reviewed the relevant documents and put together your own analysis to assist the court in determining how the defendant was in delay. Right? That's what you did. That's what you said that you did. It's paragraph 62.
May I have it, please?
I'd be surprised if you disagree.
Yeah, second witness
Let's
statement.
now.
Thank you. Which paragraph, sorry?
62.
62.
62. Thank you.
The first sentence.
No, then this is wrong. This is only 51 paragraph. Huh? So the witness statement number 3. Okay.
It's number 2. Witness statement number 2.
Number 2.
You.
I have the number 3 because there is no paragraph 16. Yeah, you have it.
Mr. Akiki, it's number 2. Witness statement number 2.
Yes, thank you. Number 2.
You should have it already.
61. Yeah, paragraph 61. Okay. Sorry, thank you. You have it?
62.
62, yes.
The first sentence of paragraph 62.
Yes.
Okay. You say that you reviewed the relevant documents and put together your own analysis.
Yes, that's correct.
Okay. Let's go now to the delay analysis again, the one that it is on screen.
Yes.
Lower portion of this document, and correct me if I'm wrong, but I think you mentioned it also earlier today. What you're saying is that concrete works, line 1,
Yes.
the one with the blue line and the green, how you call it?
Yes.
Almond.
Concrete works were completed on 9th of September 2018. That's what you say. Roof curtain eaves works were completed by 3rd of March 2019.
Yeah.
Remember when I asked you again and again earlier? That's what I meant.
Yes, that's correct.
And balcony eaves works were completed on 18th February 2019.
Yeah.
And tiling contractor had completed his scope by 30 January. And in right?
Yeah.
And in lines 5 and 6, which are based on those factors, you say that Reem should finish by 15th of March to complete its scope of works. Otherwise, Reem would be holding up the entire project, right? Am I reading this document correctly, Mr. Akiki?
Can you repeat the last sentence, please? Which one you are reading?
So
Which...
you are saying that
Yes.
So Reem had to essentially to finish until 15th March.
Yes.
Otherwise, Reem would be holding up the entire project. The hotel could not open. If Reem did not finish by 15 March, the hotel could not open. Is this what you're saying in this document?
No, I did not say this in this document, but I do confirm what you are saying. And this is what you are saying, and I do confirm the same understanding and the same principle. However, it's not mentioned in this document.
Well, how else can be explained this document? But if you confirm now, thank you. As long as you confirm it now.
Yeah.
As long as you confirm that what you are saying is that failure of Reem to finish by 15th of March, as you say it should, it meant the hotel could not open.
Yes.
This is what you say.
I'm not saying this in this document. This is your understanding, which I do confirm.
Okay, it's difficult to understand what what did you actually say in this document? But anyway,
may I say what I said? May I say what I?
And then with a big red arrow further below, you say that Reem was 170 days late until the completion of the work. Okay, so again, based on the procedure described by Mr. Al-Mahdi as to the sequence of the works, we discussed it earlier, you agreed to it in your witness statement and again earlier. Your delay analysis essentially tells us that for the works to be completed, eaves installed and tiles installed, then it must be a case that the final step on Reem's procedure, being the installation of the cover and application of sealant, what you said earlier, the cover which is only decorative and it is not important, was everything that it was incomplete, right? If you agreed with Mr. Al-Mahdi's sequence of work, and you say that on 15th of March, everything was done by the 3rd of March, all works were finished before that, and the only thing missing was Reem to fix the cover. This is the only logical explanation of what you said.
I'm really sorry. I mean, I did not say this. The delay analysis is very clear, and what I wanted to say, I already put it on the document. I do not accept interpretation this way. I'm really sorry.
Okay, you don't need to accept anything, but I'm entitled to make the interpretation, and eventually the judge will decide.
Yeah, thank you.
Mr. Carvelis. Mr.
let's move
Carvelis. Mr. Carvelis. Hello. We've run beyond the normal time for a short break. Would you like a 5-minute break or 10-minute break, Mr. Akiki?
Please, thank you very much.
Let's try and keep it to 10 minutes if we can. And then if you can be back here in 10 minutes time, that's
Thank you, because I was carried away. Thank you.
Should be 5:35 p.m. for UAE time.
Yeah.
5:30 UAE time.
2:35 for you, for my lord.
Thank you.
Thank you. Sorry, my lord. I was just caught up in another room. Sorry.
Not at all, don't worry. Yes, Mr. Carvelis. Good afternoon again.
Right. And let's see if we can expedite. Let's go to page F1981, 1981 of the bundle, please. It is a series, a set of text messages. I'm sure you've seen them before, Mr. Agigi.
Yes,
Have you?
I did. Yes, correct. I did. I have seen them.
And we see the date, which is June 24, 2019, right?
Yes, I confirm that.
Do you know who the person identified as Malik is? Is it perhaps Mr. Alam Malik, who has the email address malik@5development.com? Is he an employee of yours?
Malik is one of our engineers. He was in charge for one section of the building, so he's a section engineer.
Okay, and this was sent to a group, a WhatsApp group, 5JVC, FJVC Reem, right?
Yes.
Would you agree with me that the photo Malik sent to the group shows that part of the site, where works are required to be done by building contractors? For example, I don't see the eaves in that picture. I can't see any tiles. And it seems to me that the main contractor has grouting to do after the installation of the U-channel by Reem. Is that correct, Mr. Akiki?
Yes, at level 40, correct.
I know now the text message from Mr. Malik, it's further down, I think. It's on 11:28 a.m. on 24th of June, which states level 42 wings are ready. Team is removing gravel bin. You can see all that. We'll hand over tomorrow one by one.
Yes.
Is this reflected? Where does your delay analysis reflect these works in late June 2019?
Yes, this has been reflected already in the delay analysis, which is part of the delay caused by Reem. Because here I need to explain the context, which I quickly explained in the morning, but it's important to state it again. So level 40 and level 39, they are two mechanical floors. They have very limited work for Reem. They do not have the same scope like the other floors. They have only the glass balustrade. And these areas, they were delayed by Reem because the cradles which are provided on all the elevations, on the facades, they were given as an access for Reem to finish their works in other floors. And due to that delay caused by Reem in other floors, consequently, the access to these floors, they were delayed by Reem, and the parapet was delayed, the grouting was delayed, and the installation of the glass was delayed. So consequently, to answer your question, yes, this has been factored in the delay analysis that I have prepared.
I think my learned friend's on mute.
Mr. Carvelis, are you on mute?
I apologize. Yes, you're right. I said thank you, but let's see if you can answer my question. Can you point me in your delay analysis, which is on screen, which line shows that there are works carried on 25th of June?
Yes, you cannot expect, Mr. Carvelis, such detail to be line by line in this analysis. So
Okay.
this, yeah.
Thank you. I had my answer. Thank you. I think that's enough.
But I don't have my answer yet. I mean, you have my answer, but I don't have my answer yet. Can I continue or not allowed?
You've answered the question, I think, Mr. Akiki. If your counsel thinks there's some more to come out, then he'll ask you in re-examination.
Well, based on what we saw on the 14th on this photo,
yes,
which depicts the reality, what was actually the situation on 14th of June 2019, then if what Mr. Salim Ahmadi Al-Mahdi stated about the consequence of works, which you stated repeatedly that it is correct, then it is obvious that the AX contractor had not completed its scope on 3rd of March 2019. 3rd of March 2019. There were works but to be completed by the AX contractor on that day. Do we agree on this at least?
We agree on this for the technical mechanical floors 39 and 40, yes.
It was 39, out of curiosity, was 39 and 40 part of Reem's scope?
Yes, they were part of Reem's scope.
Okay. And again, let me read part of Mr. Al-Mahdi's first statement with which you agree. It's in paragraph 17A of his first witness statement. The main contractor would construct the civil works for the relevant floor. When the concrete was properly set and the main contractor had cleared the site for access by subcontractors, Reem would be permitted to commence works in that part of the building. So would you agree with me, Mr. Akiki, that what we see on this page with these text messages from Malik is that first step of the process for Reem to be able to carry out the works cleared for access by subcontractors, i.e., which is precisely noted by Malik, where he stated team is removing cradle beam, will hand over one by one. Isn't it what it's really meant here?
Yes, but here, to just put it in the context, this work of the main contractor have been delayed by Reem themselves. That's all what I want to add to this, yes.
So, you know, the point is, Mr. Akiki,
yes.
Your delay analysis, or whatever you call it, and you will permit me my own interpretation,
yes,
is that as though on 15th of March, 5 real estate development, the hotel manager, how you call it, 5 hotel management, Unlimited one, the owner, 5 group in general, were ready to open the hotel, but had just wait on Reem to complete its works. That's, in my view, what your delay analysis depicts, Mr. Akiki.
I respect your view. This is not my delay analysis.
Okay. Okay. Now, the point is, and I insist on that, is because 5 Group is seeking from Reem 100% of the damages that were suffered by, theoretically, the owner and by 5 real estate developers. Because the hotel did not open on 10th of March. And I put to you, how is it possible to hold the glass contractor liable for 100% of the damage when other contractors were on site at least until the 24th of June? How is it conceivable?
Yes, I can answer this if you allow me just a little bit time, because it's not a yes and no. So this answer, I need to take my time for this answer. First of all, when Reem will finish their work, this doesn't mean we will open the hotel. That statement is not accurate, and this is not reflected in my delay analysis whatsoever. Because after the completion of the work of every contractor, there are further steps to be taken before then we open the hotel. So this is just as a background of the information. Now,
Your Honor, may I please ask that you now dismiss the case entirely after this? May I make now the application for immediate judgment?
Sorry, come again.
That was a question that was, sorry for the interruption. That was for the judge.
Mr. Candelas, I think if we allow the witness to finish his answer first, then we can make whatever applications you like.
Yes.
We can think.
Yes. So for me, dealing with Reem and being contractual with them, because they have committed to deliver their work on time and with a certain schedule that I have demonstrated in my delay analysis that they have not complied and they have defaulted in their commitment. By doing this with Reem, if there are other contractors which they have similar, which I'm not saying yes or no, but just for the discussion, for the sake of discussion, if other contractors they have the same similar situation, this doesn't mean if I don't treat the other contractually, it means I have no right to treat Reem contractually. So I prefer to stick to the contract with Reem and to the case that we have and to analyze exactly what happened between us and Reem, irregardless if there are other contractors outside, they have the same consequence of the same delay that they have caused, which I'm not saying yes, I'm not saying no. So that's my answer to your question about am I holding Reem responsible for all the losses and the delays? I am holding them responsible to the amount of the delay that they have caused, and that's why I clearly said in my delay analysis there are 3 phases. There is a delay before the 13th of March, which I'm not holding them responsible for. There is a delay after the 2nd of September, when the hotel has opened. There is a delay which they have already admitted that they left the site in December 2019. So there are 3 months of delay. I'm not touching this. I'm not going there. In my analysis, I'm only focusing on the own delay caused by Reem to their work, to their scope. As simple as that.
So your testimony is, I will repeat your words the way I understood them.
Yes.
After Reem finished, there were additional works to be done for the hotel to open. That's how you started your answer.
Sorry, this was very. Yeah.
You started your answer by saying.
Yes.
Something along these lines. After Reem works finished, there were additional works to be done for the hotel to open.
That's not what I said. I can repeat clearly what I said. I said this doesn't mean if Reem, they will finish on the 13th of March, the hotel will open next day. There are other phases, maybe like OS&E, there are training, there are stuff to come. That's what I meant. I did not mean that there are other works balanced that to be done. This is an interpretation from their side, which I appreciate, but this is not what I meant.
Okay, exactly. I like exactly what you meant. My case is exactly what you meant. I will go off script now because I think I don't think there's any reason to waste any more time. Let me go off screen.
Please.
Have you issued a taking over certificate, China State?
Sorry, I did not hear.
Have you issued the taking over certificate to China State, to the main contractor?
I do not recall. I need to check my documents. It was a long time. I need to check my documents.
Can you repeat again what is your role in 5?
You know my role, and if you forgot, I mean, you can check the documents, but if you wanted to hear it from me, I'm the CEO of 5 Real Estate Development.
And you don't remember if you have issued a taking over certificate to the main contractor for a 600 dirhams project?
I do not remember now, and excuse my memory.
Have you deducted delay damages from China State?
China State, we are in discussion with them. The situation between us and them is not settled yet because of the fire incident. There are a lot of things related to the fire incident and all what happened there, but we are still in discussion with them. There are no case between us, but there are still serious discussion happening about the delay that they have caused due to the fire incident and even after the fire incident.
Have you deducted delay damages? Yes or no? It's a simple question. No, not yet. Yes.
In the determination that the engineer has done, he proposed to deduct the liquidated damages.
Have you deducted delay damages from other subcontractors?
From other subcontractors, whoever has disputed the account, the final account, we call the engineer for determination, but I don't recall which one has been approved, which one has been not approved, but there are not many. There are very few.
Have you called bank guarantees? Have you asked the liquidation of bank guarantees of subcontractors? Other subcontractors other than Reem?
Have we encashed the bank guarantees?
Yes.
No, we haven't encashed the bank guarantees.
For no subcontractor? For none?
No.
You're absolutely sure about it?
As far as I remember, yes. As far as I know, yes, we did not encash.
Okay. So, quickly, as I said, I don't think there's any point. Let's look at 2 points. We'll discuss 2 more points. I will spare you the rest. Let's talk first of all about 4.5, the famous 4.5.
Sorry.
Close.
Can I correct myself? I have a doubt of one contractor, which were the swimming pool contractors. They have a lot of damage in their swimming pools, which is not related to Reem's work. This is, I am like 50-50. I think we have encashed the performance bond, if I'm not mistaken, for them. But this is the only one, not more than this. Just I want to make sure that I'm stating all what I remember, which again, it's 50-50. I need to go back to the documents and then confirm.
No. Let's discuss the contract negotiations that occurred between the claimant and the defendant, the Reem and 5. Excuse me, sorry. Out of curiosity, this swimming pool thing.
Yes.
This swimming pool delay. Did it have any affect Reem's works? Was it connected with Reem?
No, the swimming pool, they were not related to Reem's work.
But I'm sure you saw it in your delay analysis. It's included in the delay analysis, right?
What you mean? Can you please be more specific? What you mean it's included?
Yeah, I mean, you have shown that there were works in the ongoing works for the swimming pools in your delay analysis.
But Mr. Carvelis, when I say that they are not related to the aluminium work, so how can I show it in the delay analysis of Reem. These are two
Are
different things. I mean, they are not related.
they related to the operation of the hotel?
Yes, they are related, and there are some units which we were not able to open them and use them until we rectify the swimming pools, which was after the 2nd of September.
So part of the loss suffered is due to the pools not being as they should. Okay,
Yes.
let's move on now to pay document F23, which is the work order issued. I think we may have signed it actually. Let's see the work order F23. Is this the work order?
Yes, this is the work order.
I think we can save ourselves. And because the defendant, because Reem and China State did not reach an agreement on a form of subcontract, that was the document that remained the contractual basis until June 2018, until the new subcontract was entered into. Am I right? Do you agree with this, Mr. Agiki?
That's
the basis. That was the basis for him to work on the project until the subcontract between Reem and Five. Am I right?
Honestly, I did not hear properly what you said, but if you want me to tell you what is the background of this, I'm happy to do it.
No, it's not the background. I asked if this is. Can you hear me now? Is it so difficult to hear me?
Yeah, please. Yeah, please tell me.
I think we can agree that this is the basis on which Reem carried out the works, because there was no direct agreement between Reem and China State. That was the basis.
There are two documents that based on which Reem, they started the work before the subcontract agreement is signed. This is one of them, the work order, and before this one, there is the letter of intent.
I agree. We are in agreement. We are in agreement.
Okay, thank you.
Okay. Now, I'm trying to save as much time as possible, Your Honor. I'm trying to see if I can skip a few of the questions here.
Mr. Carvelis, it seems pretty likely that Mr. Akiki is going to have to come back. I can't imagine that he'll finish in 5-10 minutes. Could someone remove this document so I can see people's faces? If he's going to have to come back, that's better. If he's going to have to come back, would it not be best to take your time to sort out what you want to ask? Because there'll be re-examination as well, I expect. And and if you've got a few minutes discrete questioning, by all means carry on, but otherwise we could stop now. And Mr. Akiki can't be here tomorrow. And what I would suggest is we stop now or in 5 minutes time, carry on tomorrow with Mr. Al-Makdi and Mr. Nair, and then have finished Mr. Akiki on day 3. That seems sensible.
I do not disagree, Your Honor.
You happy with that, Mr.
Go on, excuse me, apologies. I could go on. We have a very relatively short line of questioning about one particular point, which I might extra in the next 5 minutes, depending on how Mr. Akiki would
So
follow.
let's do that.
So that we can leave this out and we can, okay. Let's do this then. Okay, it will be, let's look at paragraph 15 of your second witness statement. This line of questioning is in relation to the suspension of the workshop after the fire incident. Just to give you a time. You mention in paragraph 15, you make reference to this unfortunate incident that occurred on 6th of August. And you say, actually, I further note that at the time of the 3 May 2017 meeting, it is in this paragraph of your witness statement, the estimated structural delays were 11 months. Did you see it? It is halfway down the page.
Yes, I can.
I further know that at the time of the 3 May 2017 meeting, the estimated structural delays were 11 months. And you take us to item 9 of the minutes of meetings. None of the subcontractors had any activity to do or works to perform during the 11 months period. This also meant that the defendant was not incurring costs because there was no presence on site for 11 months, and there was no requirement of the defendant to undertake any works. Your Honor, it's 3 o'clock UK, 6 o'clock on the dot. I just realized. Do you want me to stop and I can continue on Wednesday?
I think it's best to continue when everyone's fresher. It's to continue on Wednesday. I mean, when everyone is fresher. What I suggest we do on Wednesday is to finish Mr. Akiki before calling the other witnesses scheduled for Wednesday. With that, in which case, shall we ask Mr. Akiki to be here at 11 o'clock UAE time, 8 o'clock UK time on Wednesday morning. So you manage that, Mr. Akiki?
Yes, thank you very much for the flexibility, Your Honor. I will be present on time.
Thank you very much. Well, as for the rest of you, we will meet again tomorrow morning at 11 o'clock UAE time, 8 o'clock UK time, where we'll hear, I think, Mr. Al-Makdi and Mr. Ney.
My lord, just so I've understood correctly, tomorrow, if for example, we finish Mr. Nair, let's just say just after lunch, as an example, hypothetically, if I presume my lord doesn't want to move to the expert evidence until all of the factual witnesses are finished, just because the experts should hear all the fact witnesses, I presume.
I'd have thought it's better to finish the fact evidence before the experts. Any views, Mr. Carveris?
I do think that factual first, expert after is more efficient usually.
Yes.
Maybe we can have an early close if we get to that situation tomorrow.
Maybe, we'll see.
Yeah. All right. Thank you very much. Again, tomorrow morning, 11 UAE time. Thank you.
Thank you, my lord. Sorry, my lord, just before your lordship goes, I just wonder if your lordship would just give the usual warning in the presence of.
Mr. Kiki, as I said at lunchtime, can you make sure you don't talk to anyone about this case between now and the time you can resume giving your evidence?
Sure.
All right. Thank you.
Grateful. Thank you.
Thank you.
Bye-bye.